All you got to do is rub her neck.
I'm not.
Eve has to do that. It's Eve's job.
I'm calling this regularly scheduled April meeting of the Real Estate Commission into session for its second day. While we're waiting, as I explained to you, while we're waiting for a judge to be able to continue with the formal hearing that we have, TREC versus Walter R. Lane, we have an issue that we tabled from yesterday until this morning. And at this time, I'd like to turn things over to our attorney, Ms. Julie Kropp.
Thank you. I know we said we'd look at this a little further yesterday. The issue that was presented to us was the Commission's reinstatement policy, which in part provides as a condition for reinstatement that a licensee who's expired has to attend a 2-day meeting of the Commission within 6 months, or in lieu of attending, pay $1,500. We had an individual who contacted one of our commissioners in writing a little less than a month ago, a few weeks ago, stating that for a number of reasons he believed that this was unreasonable and that it should be reconsidered in light of his circumstances. This policy was drafted, it was promulgated several years ago, and it represents the way that the Commission's been trying to treat everyone equally. And that's the reason why it was clearly stated out of where these are the conditions. It was an attempt to treat everyone equally. If you want to deviate from that, from these conditions outlined in the policy, to prevent any sort of appearance of the Commission being arbitrary in its decision, we would need to have the individual that's wanting it reconsidered present in writing or appear to state why they believe that the provisions in the policy should be deviated from, and the Commission would need to articulate a reason why they are deviating, and that reason can't be arbitrary or capricious. It would have to be based on reasonable factors based on that individual's circumstances. And in light of this individual presenting this in writing and the Commissioner bringing this to us, stating that, you know, that this is something we may need to consider, we can consider this individual on a case-by-case basis, and any future individuals, while this policy stands as is currently written, we'll address them on a case-by-case basis and see if the Commission finds good reason for deviating from the guidelines of the policy. So at this time we can do that if you also wish.
Mr. Chairman.
Mr. Northern.
Having presented this issue to the Commission and having had legal counsel for the Commission review our policy, I would like to offer some rationale for this individual's consideration as was discussed yesterday. Let me first correct one issue that Ms. Kropp stated. It didn't just come to my attention this month. He actually made me aware of it in January, and it's taken me to this point to get it on the agenda.
I'm sorry, I was looking at the email from March, that's why.
Right. But again, as he's indicated in writing, this gentleman has been a licensee for more than 40 years. Based on his correspondence, he's had no infractions. I don't know that that's absolutely true. I've asked Ms. Maxwell to review the file, but I can assure you, based on my personal knowledge of this individual, I can't imagine that he's had any serious infractions in the 40 years that he's been doing business. He's well respected in the Memphis commercial community, and I think deserves some consideration in light of the fact that at this stage in his life he is in he spends a certain amount of time in Texas on his ranch, and at the time this issue was brought to his attention, he was in Texas and had asked for consideration of not having to come to the meeting, but when he was advised of the amount of the penalty, he felt that for the infraction, it just seemed outrageous to request that amount of money. And personally, I agree, in light of the fact that he has a good record and has been in the business as long as he has, with no serious infractions. I would ask that we give him that consideration as we agreed to do on yesterday.
Gordon, do you think you need to state the licensee's name for the record?
Thank you, Commissioner Alexander. The individual we're referring to is Meredith McCullough. He is the principal broker of Meredith McCullough Realty in Memphis, Tennessee, and the amount that we agreed to impose as penalty for his, for him not having to attend the meeting was $750. And I would ask that you all consider allowing him to pay that penalty in lieu of attending the meeting.
Mr. Chairman,
Mr. Alexander.
and able to put this on the floor for discussion, I make a motion that we reduce this penalty from $1,500 to $750 for this licensee.
Second.
We have a motion by Commissioner Alexander and seconded by Commissioner Grease that this individual, Mr.
McCullough.
McCullough, M-C-C-U-L-L-A-R, McCullough, for the record, that his penalty be reduced from $1,500 to $750 due to the circumstances that's expressed by Commissioner Northern. Any discussion on this motion?
I have quite a few concerns. Is his rationale for not wanting to be here just because he don't want to be here?
No, that's not the case.
What is his reasoning?
As I stated, he has been in the business for 40-something plus years, has a very good record with no serious infractions, and the amount of penalty associated with this one infraction of being late in reinstating his license, I think the amount is in excess of what it should
Now,
be.
my question is, why does he not want to attend a meeting? He just don't want to be here?
I've just stated that. He's in Texas several months out of the year at his ranch, and I know there are other people who are domiciled elsewhere, but at this time of the year when he's in Texas, he has certain reasons for being there, and it was just an inconvenience.
I am opposed to reducing his penalty because I would dare say that anybody who's in this audience today, had they been given that option just because they didn't want to be here to have it reduced by 50%, probably would have taken it. I think we're setting a precedence that doesn't need to be set just in favor of one person because they've been in business 40 years. I mean, after 40 years, he should know his license needs to be renewed every 2 years.
I appreciate your position, Commissioner DeCharles, but I might also add that this individual made an attempt to try and get this resolved through the commission, which every licensee has the right to do. And if someone brought to your attention something that you felt was due consideration, I'm sure you would bring it before the commission as well.
Oh, I agree with that, and everybody should. But, you know, if it was a medical reason he didn't want to be here or something, I could understand that. But just the fact that he feels it's too high a penalty, you know, I don't feel like we can show precedence to just one person, and that's my position on it.
Mr. Chairman, I'd like to have Mrs. Kropp review procedurally where we're at. I know we passed at least one motion yesterday. Julie, can you tell us what the motion is we passed?
I think for purposes of us looking into seeing if it was possible, the motion that you had passed was to amend the current policy to state $750 and retroactively date it. And the reason that you did that vote was for purposes of seeing if it was necessary for us to look into seeing if that was possible. After consulting with the chief counsels and deputy general counsel,
That's you, Miss.
it was determined this morning that in light of this being a policy that we adopted to attempt to maintain, a standard way of handling this where everyone was treated equally, this individual has requested a case-by-case review, and that for he and all future individuals who wish to do that under the policy as it's written, that's something that the commission should consider.
Retroactive to what date?
You didn't set a retroactive date, and when we spoke about it yesterday, at that time, I informed you that if we were going to amend the policy and retroactively date it, we would have to give a date to retroactively date it and give a rationale for making it retroactive that was not arbitrary or based on a single incident.
Can we then have, I'm sorry.
Oh, go ahead.
The way I understand you, so we can say a policy and say the policy is to reduce or leave it however it is, how the vote goes, as of today. But then we can take individuals on an individual case as we're doing now from thus forward. So then we really wouldn't have to do retroactive. And those 6 or 9 people, no, it was, some of them could come before us or give us something in writing and do the same thing as Mr. McCullough has.
Yes.
Well,
Which makes more sense than making it just retroactive.
right.
Is that correct?
If I'm understanding you correctly, instead of retroactively dating it for everyone, take it on a case-by-case basis.
Take it on a case-by-case. Go ahead and pass, or have we passed anything that says, yesterday, did we pass anything that said, because I think we talked about it several different times. Because I think we need to reduce it, period. The fine needs to be reduced. I like the $750. I think $1,500 is excessive. And then take each one on an individual basis that comes before us, and this is our first individual basis.
And any continuing ones after this where someone
and any
writes in.
continuing ones after that. And if I understand it right, there was only like 6 or 9 that really would qualify to bring it before us. But they were in different categories.
Mr. Chairman.
Commissioner Northern, if y'all would, for the record, when Kelly starts putting these minutes together, if y'all would, if just like Commissioner Northern just said, Mr. Chairman, I recognized him. Kelly's got to recognize everybody's voice if they aren't identified on these minutes, and it makes it easier for her if she knows who's speaking. So with that thought in mind, Commissioner Northern, you have the floor.
I just want to state again, as I stated yesterday, when we first visited this issue and came forward with what we deemed to be a policy, it was always with the understanding that individuals still had the right to appeal to the commission. That right was never taken from them. This individual simply appealed to the commission, and I made the presentation for him. It's not being treated any different than the original intent of what we set out to do. It's just that this happens to be the first time that it's brought to your attention. Now, some of you were not on the commission when this was done, but I was, and I know specifically how it was addressed. And that we have never, as a body, done anything that takes away the right of a licensee to appeal to this commission. And I would hope that we would never do that.
Mr. Chairman.
Commissioner Alexander.
That being the case of any licensee or any infraction, you have a right to appeal what this decision that this commission has made. It's never changed, and I hope it never changes. where you have, and when you don't have the right to appeal it.
Commissioner Austin, Commissioner McMullen.
Julie, could you go back through the numbers one time as far as people who have been assessed this civil penalty? How many are in the various states?
I think Eve has those
Okay,
numbers.
Eve, could you do that?
First off, just to sort of put it all together, there are 107 people that have paid the $1,500 from the beginning. Currently, there are 63 people that are here and attended, or either paid and already attended, so they're out of the question. There are another 34 individuals who are in various stages of paying or attending. There are 12 that have paid and not attended. So they paid just their penalty payment, not the buyout of the meeting. They've paid and not attended. There's 7 who are not sure when they're going to attend. There's one person attending in July. There are 4 people who are attending in May. There are 10 others who have been sent reinstatement orders from whom we've gotten no response. And then there are others who've called about reinstatement, and when we tell them what their penalty is or what the reinstatement policy is, they either tell us they'll call them back, or we've just sent them information and they haven't acted on it. They didn't get it calculated up. When we get someone who wants the information calculated, what we do is we calculate their penalties on a sheet of paper that has the months lined out, and you can say it's 50 for this month, 50 for this month, so they can see the progression. And then they also get a reinstatement order, which is basically the policy, and filled in with their specific information. And then a number of people sign that, pay the penalty amount, send it back in, and then they have 6 months to attend a meeting.
If we were going to do in some form of retroactivity on this policy, how difficult would it be to issue refunds to people who had already paid the whole amount?
Some of those people go back to the inception of the policy in 2008, so I think that would be pretty hard to do.
Right.
There were 44 that have paid in 11 and 12, so I think it'd be, I don't know, I think it'd be like from 1/1 of 2011 to 4/3 of 2013, 44 people have paid. I mean, the other people are pretty far removed.
Does the difficulty in issuing refunds to people who have already paid provide a rational basis for drawing the line on retroactivity at people who've already paid versus people who have not already paid the amount?
That would be you all's decision. I don't know. I mean, I don't know.
Commissioner, I want Commissioner Northern, and then Mr. Pugh will be after Commissioner Northern.
Let me state that this is not an effort to make anything retroactive. It's simply responding to a request by a licensee. And the numbers that Ms. Maxwell have given us, Ms. Maxwell,
Yes.
do you know whether or not any of those individuals asked to appeal to the commission?
I don't know whether these individuals have asked. I mean, we've had a number of people ask in the past.
And I think therein lies the difference. This individual asked to appeal to the commission. And I think, if I'm not mistaken, it was asked of staff, and then it was asked of me. And I presented it to the commission. That's a difference from people just agreeing on an agreed citation and sending in their money.
The policy was changed in August of last year and took out the request provision, so that if your license was expired for more than a year, you had to retest and reapply, so that those...
Was this individual's license expired for more than a year?
No, but I mean, no, it was not.
Okay.
But there was not a provision there was never a provision, there was never a provision that they could ask. But we do
I
have
don't
people
see the
ask.
relevance in what you're saying, then.
Well, okay. We do have people that ask that to appear, even about the penalty amount. It is assessed.
And they were not allowed to come to appeal to the commission?
That's a point we need to discuss, too.
I mean, that was never discussed, whether they, I mean, we tell them what the penalty is, and that's what's written in the reinstatement policy. If you want those people to be able to come as well and discuss the penalty amounts, then we can tell those people as well that they can write in.
I'm not asking us to do anything different from what the commission says, but anytime a licensee calls or writes me about an issue, as you well know, I forward it to you and request, if it's of that nature, that it be put on the agenda. That's all I did in this situation. It is not singling out any one individual for any special favors. This is just the way the commissioners agreed we would treat licensees' requests for consideration.
Well, I personally had someone...
Wait,
I'm sorry.
I'd like this time to turn the floor over to our Deputy General Counsel, Mr. Wayne Pugh.
If you tap it on the top like that, it'll usually come on.
Just talk a minute. Say 1,
Or
2,
hit
3.
that speak button.
Say 1, 2, 3.
Oh,
Louder.
that
There you
okay.
go.
Let's get back. And yesterday when I came in, I was explaining a little bit of difference between what a rule and what a policy. Policy can in fact impact your internal workings. What you guys did, I think this goes back to 2007, is you looked at this issue. Anyone whose license has expired over 60 days has to reapply to the commission. The commission has the discretion of reinstating that license if they and they can impose reasonable conditions and things. What you guys did in 2007 is say, okay, we're going to set down in writing how we're going to treat these people as far as how you look at it in an attempt to kind of make sure everybody is treated equally. Because one reason a commission's decision may be overturned if it is arbitrary and capricious. If you treat someone differently than how you treat other people, that could give rise to that type of argument. So that's why you did the policy. It was not a rule, never was intended to be a rule. And Commissioner McClellan, to correct you, you have not assessed any civil penalties. What you have offered is this, you can do this and have your license reinstated. This is the policy of the commission. This is the way we're kind of treating this. If you want to go ahead and agree to that, then fine, you can get your license reinstated. If someone doesn't, then they should have the ability to come in and the commission take a look at the set of circumstances as to whether they want to reinstate that license. Going forward, if you guys want to say, okay, you know what, we've looked at this has been brought to our attention, and you kind of want to make as far as how you view this and reduce what you're looking at, which we're going to go back and look at all 12 of your policies to make sure that we're not really doing rules. Because if you do a rule and you're treating something as a rule that has not been properly promulgated under the UAPA, that's void. I mean, the courts are going to look at that and say, that's no force and effect whatsoever. You can't enforce that. So we need to take a look at your policies. But in this situation, you've had this where the people can reapply to you, and you have the discretion of whether to grant them the reinstatement or to say, no, you have to go back and just reapply and do the test and everything. So this talk about retroactively on the policy, you don't need to do that. You need to look at this individual and see whether you want to reinstate his license, and then if you want to re-examine how the general guidelines, which is what your policy is, of how the commission looks at these on an individual basis, you can do that. Does that help any?
So the policy is that, tell me what the policy is right now.
The policy, I think, now is that you guys have been saying if they didn't want to attend a meeting, that you were going to, they could pay the $1,500 rather than attend the meeting as the reasonable condition to have the license reinstated.
So if we just want to say that you could change the number from $1,500 to $750,
going forward, you say, you know what, we do, after this brought it up and we've had this discussion, we think going forward that maybe that is too high, maybe we need to reevaluate our policy and how we view these things.
And it's not a retroactive application of that policy to this person if the check for $750 comes in the door after we've changed the policy to say a check for $750 is fine, right?
You want to change your policy right now, I mean, because what you're going to do is look at the matters going before. And as Isaac, Commissioner Northern and Commissioner Alexander say, everybody has the right to come in front of you and say, wait a minute, I want my license reinstated, but I have specific circumstances that I think I should be, I may need to be looked at a little bit differently. But you need to be able to articulate why you're treating someone differently than everybody else.
So did we vote yesterday to change the policy to $750? Didn't we do that?
Yes,
and
we
you
did.
voted to make it retroactive, but you did not give a date or a reason. So it might be a new. You might need to do a new motion to that effect.
Take the retroactive part out. Okay.
But we got a motion on the floor. We need to do that after we take care of this motion.
Would you,
Motion on the floor is to reduce the amount of civil penalty for reinstatement for Mr. McCullough from $1,500 to $750, and it was made by Commissioner Alexander and seconded by Commissioner Grease.
Well, isn't that already taken care of by the policy we passed yesterday?
We tabled until today what we were doing yesterday.
Chairman, I call for the question on the
would
motion.
you all like to know, just because when he stated in his information that he didn't believe he'd had any other infractions, would you all like to know the information that we have in the licensing file before having your vote? Okay. We do show in the licensing file that in 2009, Mr. McCullough paid an agreed citation for failing to obtain E&O insurance. And there was also an agreed citation in September of 2001. It was approved in October of 2001, which appears to have been for reinstating the license later. There was also a complaint against Mr. McCullough, looks like maybe in 2003 or 2004, but that was dismissed. Those are the only issues that we that were in the licensing file.
No, Commissioner Alexander, you've called for a question, but I'm going to ask one question to our legal counsel, our deputy legal counsel. I know this commission has the authority to do what has been, the motion has been made and seconded and discussed. We have that authority. I'm going to ask you, Mr. Pugh, is this, in your opinion, are we opening a can of worms? No? Okay. That's all I wanted to know.
Mr. Chairman, again, I call for the question.
I know. Miss Maxwell, would you call the roll?
So this is a vote on the matter of whether to reduce Mr. Meredith L. McCullough, license number 52430, his meeting amount to buy out of coming to the meeting from $1,500 to $750. Is that correct? Okay. Alexander?
Or the motion.
Collins?
Or.
DeChara?
Against.
Reese?
Yes.
Flitcroft?
No.
Haynes?
Yes.
McMullen?
No.
Northern?
Yes.
Stevenson?
Yes.
So it's
And I think in this case, I think the record should show that Commissioner Northern, I would think, you think you should recuse yourself from this vote?
I'll gladly do that.
I think you did last time. Did you?
Because he brought
Just
it.
because I brought it, I don't think
Doesn't
it's
mean
grounds
he
for me
should recuse
recusing
himself.
myself. But if you prefer that I do that,
I mean,
are you related to him or something?
I have no personal interest with this gentleman at all.
Well, you just brought something before us then.
Okay. Mr. Chairman. Commissioner, what was the vote?
The vote was 6 yes and 3 no.
Okay.
So now that we've got that handled, did it make any difference? I mean, is our policy $750 at this point, maximum fine in any case? Did we accomplish that yesterday, or do we need to ratify that in some form or fashion today?
I think that since your motion included possible retroactivity yesterday, it should possibly be a new motion today. It would then be adopted and effective today and going forward from today.
Mr. Chairman,
Commissioner Alexander.
there was a motion yesterday to table this until today. I move that it stays on the table until staff has time to review it further and come back and report to us next month.
I would second that.
Putting that in the form of a motion, directing staff to make a recommendation to us next month. Commissioner
They
Alexander.
don't have to make a recommendation, but they can study it, and this commission then can come back. This commission can come back and make its own decision. I don't think they can make the decision for us. They can come back and study it, make a recommendation to us, and then we'll just consider that from then. And I made the motion yesterday. I made the motion, then I made the motion to table it, and I'm going to make the motion again to table it.
Would you restate your motion?
Simple.
Please do.
That the motion that was made yesterday about the reduction of the fine and the retroactive date, all of it stays on the table until staff has time to further review it and come back and maybe make this commission some recommendations.
When?
Next month.
Next month. Okay. You've heard the motion.
Provided they have time to do it within.
Do I hear a second to that motion?
Mr. Northern,
Mr. Northern, second that motion.
so I'd like to offer a substitute motion, Mr. Alexander, my friend here. I mean, what's there to study? If it's gone from $1,500 to $750, it's not going to be retroactive. Maybe that's the issue that you want to study. But I think Mr. Pugh said there's no reason for it to be retroactive. If we change the policy going forward, that's what it is.
If you want to do it today, then make the
Well, I'm getting ready to make that substitute motion. That
Have a motion on the floor right now.
well, I can make a substitute motion and amend it. I don't want to amend it. I want to make a separate motion. I think I can do that.
Mr. Ms.
Withdraw your second, withdraw your motion.
You got to move the motion off the table to be able to vote on
Not on
it.
the substitute. I don't have a second. That's my motion would be to confirm that the maximum penalty in the cases we've been discussing will be $750 going forward, with no reference to retroactivity.
I second that.
I'll second that.
We have a motion, and I'm going to have to rely upon Commissioner Grease. He spent 8 years on town council,
It doesn't matter what my level
plus 12 years as a county commissioner in Knox County, so he's been in a lot of meetings with different parliamentary procedures, and a substitute motion, and that you've heard the motion, and we've got a second by...
I want to suggest to him that we treat this like we have said we would do with any other individual. If they don't want to pay the $750, they have a right to appeal it.
I don't want to take that away. I don't think we've ever. That's
No, I wanted to be sure that we understand that everybody has the opportunity.
Yeah, we've got
before
John Grease's motion on the floor has been seconded by Commissioner McMullen, and we're discussing it. And Julie,
Mr. Chairman,
Commissioner Northern.
just for the sake of being clear here, did we dispose of Commissioner Alexander's motion? Was it withdrawn?
Okay,
I mean-
explain to us a substitute
Yeah,
motion.
parliamentary procedure.
Tell
You're
us-
my parliamentarian.
Vote on the substitute motion first.
The substitute motion is on the floor right now. If it passes, forget Commissioner Alexander's motion. If it
It's
fails, you go
substitute
back
his
to his motion.
Okay, gotcha.
So vote for yes, vote for your motion.
Oh, for Grease.
Okay.
Question has been called. All in favor on the motion that was made by Commissioner Grease and seconded by Commissioner McMullen. All in favor say aye.
Aye.
Opposed, no. Motion carries.
So that substitutes your
That
motion.
disposes.
His is gone.
that disposes of his.
At this time,
Can I ask a question?
Yes, you can.
So I know the way to tell the staff. So when someone calls in and they want to reinstate, and they don't want to either pay the amount of the penalty or pay to come to the meeting or buy out the meeting, well, should we tell them to write the commission, and then we'll bring each of those to the commission to determine what will be done in that instance?
Northern is the main.
Okay, I just want to make sure that it's penalties
For 2 more
and...
months, though.
So yes.
And that's been, that was my biggest problem with it anyway, was because I know somebody that was not given that option, and so that's kind of why I had that problem. They were not given an option to appeal that.
That they show up.
Well, if they show up, do they have to come with their principal broker?
A lot
We
of
have a policy, that's what I want to know. I just want to make sure they're done. Okay, all right. I just want to make sure I
Mr. Chairman, I got one other question on this last one.
Mr. Collins, Commissioner Collins.
When we give somebody a break on 750, I think the time frame of payment should be set in 10 days. Otherwise, it might be 6 years.
Mr. Chairman,
Commissioner Northern.
I think if you're allowing someone the right to appeal, whatever consideration is being made should be made during the appeal process. I don't think we should set a policy on how we're going to treat an appeal.
We will come back and discuss the policies next month. That's your next.
Perfect.
Okay.
Too
Go
close to
forward.
the subject.
You have a judge here now. Then.
Yes.
At this time, we have a matter before this commission, a formal hearing, TREC versus Walter R. Lane, docket number 1218-120150A, complaint number 201-2014-241. And we have a judge from the state that is here, and I'm going to turn these proceedings over to our judge to proceed and instruct us as to what we need to do and how we need to do it.
Thank you, Mr. Chairman. First of all, I want to apologize if there was any delay in the commencement of this hearing this morning. As you know, you have this hearing at 9 o'clock, and you have another matter at 1 o'clock. Judge Safley has this docket, and she mistakenly thought both cases were at 1 o'clock. She has a commitment this morning, and that's why she's not here. So I'm substituting for her this morning. Apologize for the delay. She'll be here this afternoon.
If I could, Judge, Your Honor, just so we will all know, I know you've been with us before, but so all the commissioners will know your name is.
Oh, I'm sorry. I was going to get to that. My name is Tom Stovall, and I'm the I'm the Director and Chief Administrative Judge in the Administrative Procedures Division at the Secretary of State's office.
Thank you, Your Honor.
This matter now, Walter Lane. Ms. Ryan, do you have a copy of the notice of hearing and charges?
I do.
What I'd like to do at this time, if I could, is have that notice passed to the board, let the commission, let them take a moment to review it, and then we'll formally open the proceedings. All right? All right, Mr. Chairman, it would appear that most members of the commission have reviewed this document. I'll go ahead and open the proceedings at this time. This is a hearing before the Tennessee State Real Estate Commission to consider the matter of Department of Commerce and Insurance versus Mr. Walter R. Lane, unlicensed, of Knoxville, Tennessee. As I previously stated, my name is Tom Stovall, and I will be serving as the administrative judge in this hearing. As the administrative judge, I will not participate in the decision that's made on the merits of this case. That decision will be made by the members of the commission that are present this morning. Would the members of the commission that are present please identify themselves for the record?
David L. Flitcroft.
Grover Collins.
Janet DeChara.
Bear Stevenson.
Michelle Haynes.
Isaac Northern.
Austin McMullen.
John Grease.
Wendell Alexander.
Thank you. Members of the commission are reminded that their decision in this matter must be based only upon the record that is produced during the course of these proceedings this morning. Now that you have reviewed the notice of charges, I would ask if any member of this commission has received any ex parte communications about this matter or has any prior knowledge about the facts of this case or any familiarity with the respondent, Walter Lane, that would make them unable to hear this case.
I do.
I'm sorry, I didn't see who's... Mr. Flitcroft? Are you
I'm a practicing
disqualifying
lawyer in
yourself?
my other life, and I've done quite a few closings for Mr. Walter Lane.
All right. Are you then disqualifying yourself from this
I
matter?
am disqualifying myself.
Thank you, Mr. Flitcroft.
Your Honor, I've had dealings with Mr. Lane before, and to avoid any appearance of conflict, I suggest that you allow me to be removed as well.
All right. Thank you very much, Mr. Crease. Anybody else? Does that still leave a quorum, Mr. Stevenson?
Yes, sir. We have 7 out of our 9.
All right. Very good, then. I appreciate Mr. Flitcroft and Mr. Crease on this matter. The record show that Ms. Robin Ryan, Assistant General Counsel with the Department of Commerce and Insurance, represents the department in this matter. The record also showed that Mr. Lane is not present, nor is an attorney present on his behalf. The record consists of the notice of hearing and charges that was filed February 21, 2013. That has been reviewed by the commission. We also have pre-hearing orders that were entered in this matter, one on February 28, 2013, and the second on March the 18th of 2013. We also have the witness and exhibit list that was filed by Ms. Ryan on March the 20th of 2013. Ms. Ryan, I understand the department intends to move to hold Mr. Lane in default. Is that correct?
We do, Your Honor. Let me explain, though.
Please, go ahead.
We have attempted service on several occasions. Initially, the addresses we have from Mr. Lane, who was a previous licensee, one address came back from the department itself as not good. Then, in the previous matter, Ms. Kropp sent a letter to the other address we have, certified mail, which was signed for. But this was back in November. This was then assumed to be a good address. 2 months later, by the way, we got that document back. But having said that, I did not. But having said that, we then attempted to serve Mr. Lane at the same address, certified mail. The document from the United States Post Office says it was attempted, is very unclear. But we did find that it too was returned to us. At that point, I had Ms. Kropp call Mr. Lane. She had had previous conversations with him. And if the court please, I would like to put her testimony on about service with Mr. Lane.
Very good. Ms. Kropp, you want to?
Raise your right hand, please. You solemnly swear or affirm the testimony you give in this cause will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, ma'am.
Please state your full name.
Julie Kropp.
And your position with the State of Tennessee?
I'm Assistant General Counsel and Board Attorney to the Tennessee Real Estate Commission.
Now, you heard me explain to the judge that you'd had a personal telephone conversation with Mr. Lane. Could you tell us about that conversation?
My first conversation with Mr. Lane was in October of 2012 when I had received this complaint for review, but prior to the presentation to the commission, and I spoke with him at that time regarding the complaint that we had received, and the complaint was returned to our office, and so I made contact with him by telephone in order to address the complaint.
And did you have a subsequent conversation with him?
I did. I again spoke with him on March 18th, 2013.
And what was the gist of that telephone conversation?
I explained to him that that I wanted to confirm that he had received the notice of hearing and charges. He indicated that he had not. I explained to him that a consent order that was sent in November had been signed for at the last known address that I had found on file with the Commission through our regulatory board system. He inquired as to who signed for it, indicated that he had not received that, and at that time provided his email address to me. I confirmed by reading it back to him, and then I gave that information to you to have the notice sent to him via email on that date.
Did he ask you to send the notices via email to him on that date?
I don't recall if he asked or if I told. I obtained the email address, and he indicated that he would receive it that way. So he indicated understanding that it would be sent that way.
And that email address, do you have the address?
I wrote it down in my notes.
Okay. Do you have your notes in front of you?
I have a copy of my notes that I took.
And what is that email address?
W. Lane, spelled Lane, dot benchmark, BENCHMARKCO, at charter.net.
And that's the address you provided to me?
That's the address I provided to you.
Thank you. Your Honor, at that point on March 18th, I then also sent everything via email on both the 18th and on the 19th to Mr. Lane via email, all the documents that were that Ms. Kropp spoke to him about. And I have a copy of the email sent. I've not heard anything back from him. Earlier this week, Judge Safley also contacted me asking for the email address for Mr. Lane, and she then wrote to him as well, giving her phone number and asking him to call. And as far as I know, she did not hear from him. But and prior to filing this in the first place, I would want the court to know that I did check addresses online to see if there was another good address, and this was the best address that we had for Mr. Lane.
Which address was that?
And that address is the one where it was accepted for service last fall at 7090 Kingston Pike, Suite 110, Knoxville, Tennessee, 37919.
All right. And I will state for the record that the pre-hearing order that was originally entered in this matter by Judge Tony Agent on February 28 of 2013 that was mailed to 7090 Kingston Pike was returned as undeliverable and unable to forward. Would you put the email into the record, please, as exhibit number 1?
Would the court also like the copy of the letter
Yes.
where the document was accepted?
Yes, so we'll make that 1 and 2, please. Ms. Kropp, could I ask you a question? When you spoke with Mr. Lane on, was it March 18, did you say?
March 18th, yes, sir.
Did you tell him that the hearing was scheduled for today, April 4th?
No, I don't have that in my notes. I believe I said that there was a notice of hearing and charges sent regarding a hearing that was to take place, and I asked him if he'd received that, and he indicated that he had not. And so he then provided me his email address to send it to him via that medium.
And Ms. Ryan, you say that you emailed him the notice of charges on March the 18th.
Notice of charges, the witness and exhibit list, and on the 18th, and again send it on the 19th. None of those documents were returned to me via email or as undeliverable via email.
And Ms. Kropp, you say that Mr. Lane indicated to you when you spoke with him on the 18th that he had not received the notice of hearing prior to
Right, and
that.
he questioned, when I told him that I had sent a consent order back in November that had been signed for, I believe he asked me, well, who signed for that, and indicated confusion as to whether he had received that or not. We had a signed green form return where an individual named E. Buchanan had signed for that on 11/16/2012. Later in January of 2013, that same envelope was returned to us, opened, saying not deliverable, which is confusing in light of the fact that someone signed for the same material in November.
Thank you. Anything else, Ms. Ryan?
No, Your Honor.
All right, members of the commission, it is, when we have a motion for a default, it is the decision of the judge on the legal matter as to whether or not proper service has been given, and then it's ultimately the decision of the commission as to whether or not to grant the default or to continue the case. It would appear from the record here that Mr. Lane did not receive notice of this hearing. I believe he does have actual notice, but I think he probably did not receive notice of the hearing and was made aware of the date until March the 18th or 19th, which is some 15 or 16 days ago. He clearly has notice of the hearing, and so, but I'm going to, obviously at this point, I'm going to defer to the commission as to whether or not you wish to hold him in default or whether or not you wish to deny the default and continue the matter till the next setting to ensure that Mr. Lane has notice of the hearing and has adequate time to prepare a defense. I will say that the record does not indicate that at any time in the last 16 days that Mr. Lane has communicated either with Ms. Ryan or with Judge Safley to the effect that he would not be able to appear today or he needed more time to prepare a defense. There has been no communication from him since Ms. Kropp spoke with him. So with that said, Mr. Chairman, I'll turn it over to you.
You've heard the testimony given. You have heard the comments made by Judge Stovall. We've got to decide, do we want to move forward or we want to hold Mr. Lane in default in this matter? Anybody like to make a motion as to how you think we need to proceed in this matter?
Mr. Chairman, I move that we hold Walter R. Lane in default.
Second.
I have a motion by
I didn't hear.
Commissioner Collins. Commissioner McMullen makes a motion that we hold Mr. Lane in default in this matter, and seconded by Commissioner Collins. Discussion on that motion. Hearing none, all in favor say aye. Aye. Opposed, no.
2 abstain.
Motion carries with the 2 abstentions, Mr. Flitcroft, who has recused himself, and also Commissioner Grease, who has recused himself.
All right.
Your Honor,
I'm sorry.
move forward.
I'm sorry, Mr. Chairman. All right, members of the commission, the motion to hold Mr. Lane in default has been granted, and at this time we allow the state to proceed with this case. Ms. Ryan?
Thank you. This is a fairly simple matter. Proof will show that a complaint was opened against Mr. Lane, who previously held a license with the state, but that the license in question expired in 2010. In June 2012, TREC being the Tennessee Real Estate Commission, received information showing the respondent was using a yard sign advertising the sale of property with his name, expired firm, and phone number. In October 2012, additional information received from the Knoxville area of realtors show that the respondent was still listing 2 properties under his name. Excuse me. Proof will show that he was sent a cease and desist letter in June of 2012 at a previous address, and that letter was returned unclaimed. Proof will show that this matter was then presented anonymously before this commission, and the consent order was served on him in November, but he did not respond or pay. This is the consent order that has been previously spoken of, where indeed someone claimed and signed for, and then it was returned 2 months later. It is unknown today whether he's still advertising properties, but he did tell Ms. Kropp in one of her phone calls that he did not realize his license and his firm license had expired 2 years previously. We are asking today that he be assessed a civil penalty, that he be ordered again to cease and desist, that this matter be a consideration of any future application for a license in this state, and that he pay all the court costs associated with this matter.
All right. I'd like to call your first witness, Ms. Ryan.
I call Eve Maxwell.
I solemnly swear or affirm the testimony you give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Would you please state your full name for the record?
Eve M. Maxwell.
And your position with the state of Tennessee?
I'm the Executive Director of the Tennessee Real Estate Commission.
And as the Executive Director, are you familiar with both the complaint file, that is the complaint that was filed against Mr. Lane, and his license file?
Yes, I am.
Does he have a current and active license?
No, he does not have a current active license.
When was he originally licensed?
He was originally licensed as an affiliate broker on 9/19 of 1978 and was licensed as a broker on 10/29/1980.
And when did his license expire?
His license expired on 12/17 of 2010.
And at the time of the expiration of his license, where was his license held?
It was held, he was the principal broker of Benchmark Realtors, and their license number is 60094.
And when did that license expire?
That license expired on 9/8 of 2010.
And since that time, are you aware of anybody working in the firm license that at the firm license address besides Mr. Lane?
No, I'm not aware of that.
What was the reason this complaint was opened?
This complaint was opened because Trek received anonymously information that Mr. Lane was advertising using a Benchmark sign with Benchmark Realtors and then Walt Lane listed on there, and so he was sent a cease and desist.
Benchmark being the firm that had the expired license?
Correct, Benchmark Realtors.
Were there pictures sent with that?
There were pictures sent with that. There were two pictures sent with that show the sign in the yard, the Benchmark sign with Walt Lane's name on it in a yard sign.
I'm going to ask you, please, to look at the document that Ms. Kropp is going to hand to you and ask if this is indeed a copy of the complaint file with the picture of the sign in question.
Yes, that is a copy of the complaint. That was
And after that, and after you sent a cease and desist or prior to it, did Mr. Lane ever contact you about that matter?
Not that I'm aware of. He never did.
Your Honor, and before I go on, I would ask that if I'm be permitted to pass out a copy of the complaint that includes a picture that's signed to the members of the commission.
Going to make this an exhibit?
I do.
All right, let's mark this as exhibit number 3.
Under the records, your records show is the last time you've heard from Mr. Lane.
The last time I personally have not spoken with Mr. Lane at all.
The office, then?
The office. I don't, last time it appears that we received information from him was when he last renewed his license, which was on 1/10 of 2009.
You've not heard from him at all since then?
No, not to my knowledge.
There have been no attempts to renew his license to your knowledge?
Not to my knowledge, there have not been.
And this is even after he spoke with Ms. Kropp in the fall, saying he had not realized the license has expired?
That is correct.
Do you know if he's still working and using his old sign as advertisement?
The only information I have is the information that's contained in the complaint.
Thank you, Ms. Maxwell.
Members of the commission have questions for Ms. Maxwell.
I have one, Ms. Maxwell. Has this commission ever, with certainty, been advised or have knowledge that Mr. Lane has ever received anything we've sent him other than the emails?
You mean through the years, or
I mean, since his complaint was filed in this matter that's before us, is he? I know this shows on this exhibit, mark number 3. It says on here that the reason it's unclaimed, he didn't pick it up. The certified mail that was sent dated the 12th. June 25th, 2012.
If the court please, may I interrupt? I should have. What address was that document sent to?
This address, the complaint document, was sent to 2897 Lakeside Drive, Lenoir City, Tennessee, 37773.
Is that the same address where there was a document sent by Ms. Kropp in last fall that there was accepted service? Well, let me have you look at it. Julie, could you provide a... Come here.
Question while looking. Right.
I'm showing you a document that Ms. Kropp sent that was accepted for by someone in the office. Is that the same address?
No, the address that where something was accepted by the office was 7090 Kingston Pike, Suite 110, Knoxville, Tennessee, 37919.
And the date on that, please?
The date on this, November the 14th, 2012, is the date the certified mail receipt is stamped.
So that is subsequent to your cease and desist letter of June, is that correct?
That is correct.
And in a different address, is that correct?
That is correct.
Thank you.
Stevenson, did you get an answer to your question?
Yes, sir.
All right.
The picture, Ms. Maxwell, the pictures I don't see a copy of the actual complaint. It was an anonymous complaint. How was it filed? Somebody just sent you photographs?
Which is frequently the case with advertising or unlicensed activity.
How do you determine when these photographs were taken?
Well, normally they are dated. These were not dated, so we could see that this person was not licensed. I mean, his license had expired. Both his firm and his license had expired, so we sent him a cease and desist.
How do we know the pictures weren't taken 10 years ago?
They could have been taken 10 years ago. He started working for Benchmark on 3/25 of 92. I mean, they could have been the anonymous information, came in right before we opened cease and desist.
We have an anonymous person that sent pictures of 2 yard signs. Were they listed in the MLS somehow during that time where we have a date on it? So we don't really know. I mean, how do we determine that the pictures of the yard sign were taken during the time that he did not have a license? I mean, they could have been taken, like I said, 10 years ago. How do we know? Where's our proof there?
That is correct, and that's why we send a cease and desist, so that the individual can answer and tell us what their situation
It's
is.
the same sign, but I mean, how do we know when that picture was taken?
Okay. MLS.
Okay.
That's why
It was
as I
in
say,
MLS.
it-
Okay.
Yes.
So it was also listed in MLS, and that is date sensitive. Okay.
And,
Okay.
And as I
just
say,
didn't-
that's why we send a cease and desist. That gives a person an opportunity to tell us.
And he just never did respond.
He never did respond at all,
He
correct.
couldn't have said, oh, well, that was taken in 2009. I hadn't had that house listed. But it was in the MLS, and that was date sensitive. And do we have copies of that MLS?
I don't have them in my file.
Okay.
Ms. Maxwell,
Yes.
do we have a copy of the listing agreement on these houses in your file or somebody's file? If you don't have them, who's got them? Ms. Carper, you got them in your file?
We don't have copies of the listing agreements on these houses. I don't know the address of the houses. That's not in my file.
Then how do you know whether these houses were owned by somebody else or whether they were actually owned by Mr. Lane?
If I might interrupt, I'm sorry to say, but I wanted you to know that I do have other evidence to present that is not going to come through Ms. Maxwell.
Okay. And you want me to direct my questions to you, ma'am?
Well, to my other...
What we need to do is finish with our questions for Ms. Maxwell, and then we'll hear from Ms. Ryan's other witnesses.
Mr. Chair, I have a couple of questions for Ms. Maxwell. Ms. Maxwell, you said that Benchmark's license has also expired.
That is correct. The Benchmark for which he was the principal broker.
Do we know have we sent an auditor or anything to confirm whether Benchmark is still operating or not?
There has been an auditor go by there. There was no one there at the time.
Is the address on Kensington Pike, is that Benchmark's
Kingston,
address?
7090 Kingston Pike, Knoxville, 37919, Suite 110.
Is that Benchmark's?
That's Benchmark's address of record in our file, in the track file.
So that would indicate that somebody was at that office doing business in November, and the firm was expired at that time.
That's where there was a signature received.
Okay, thank you.
Commissioner Northern's next.
Ms. Maxwell, the comments given by Ms. Ryan earlier indicated that the property was advertised in the MLS. Has there been any contact with the MLS to determine whether or not that is in fact the case? Since this individual was unlicensed and the firm is unlicensed, typically MLSs would not allow you that opportunity without you being properly licensed. Was there any effort made to contact that MLS to determine whether or not they were actually advertising there?
That was done by a department other than our department.
That proof to come later, Ms. Ryan?
Yes.
Thank you.
Mr. Collins?
That was one of my questions. Do we know whether or not he owned this property or had an interest in it? And in our MLS, you can't enter anything into an MLS unless you are licensed by the state, and there's a fine. Do you know if the MLS has fined him for any reason?
I don't know what the MLS has or hasn't done in regard to that.
Thank you.
Ms. Maxwell?
Yes.
When the auditors went to this address, is there any indication that there was a sign that Benchmark's property or their advertising or their signs was on this property?
I would have to look at the audit and see what references were made as it relates to the sign. So I can't answer that question at the present time.
Anything else from Ms. Maxwell from the commission? No? Ms. Ryan, anything else? Thank you, Ms. Maxwell.
Next call, Julie Kropp.
Your Honor, at some point, we're going to need to probably take a short break.
Oh, all right. You want to do that now, Ms. Stevens? Or how long is will her testimony be?
Slightly longer than Ms. Maxwell's, maybe.
Let's do it now.
Let's go ahead and do it now.
Let's take a short
Okay.
recess then.
Call these proceedings back into order.
All right, I believe we, Ms. Kropp, right, Ms. Ryan? Ms. Kropp, you remain under oath.
And so there's no confusion. State your full name.
Julie Kropp.
Now, as the attorney, Ms. Kropp, for Trek, did you have occasion to review this complaint that was filed, anonymous complaint filed against Mr. Lane?
Yes, I did.
What did you do after you reviewed it?
When I received the file with only the picture in it, I realized that there was no date on the photograph, and therefore, before I presented this matter to the commission, I wanted to see if I could gather further information as to when the sign was posted.
And what did you do to gather that information?
I made a telephone call when I began reviewing the file to the number. Let me see. Let me verify. I'm going to look at the copy of the complaint to see if this is where I got the number from. The number on the sign in the picture,
right.
I called that number just to see what I would get and who would answer and what information I could get. The person that answered that call was Walt Lane.
And what did he say?
He told me that sign was on property that he owns personally. I asked him how long, I said, I don't know when this sign was up. I realized your license expired about 2 years ago. I don't even know when this was from. He indicated that the sign had been up pretty recently. He wasn't sure if it was up that day. And he said he wasn't aware that it was a problem, but he, at that time, sort of cut me off, told me he was in a meeting, and then he would call me back.
Did he?
He did call me back. I was out of my office at the time. He left me a really long message that basically, I took notes as best I could from that. The gist of it was that this was the only property, and he did not give me the property date in our first phone call. As I said, it was a very brief phone call because he told me he was in a meeting. He said it was the only property that he and his wife owned. I have in my notes he didn't realize the license expired. He might have just meant for a period of time. I'm not positive, exactly. It was a long message, and I took notes as best I could, but he indicated that he'd fallen off a roof, and he had asked the staff, Trek staff, about reapplying sometime in the future, etc., and he said to call if I had any more questions. I did not call him because in the meantime I'd done some research which led me down another avenue.
And tell me the research you did.
I looked on the internet, just kind of searched his name and benchmark, and on the internet, on the Knoxville Area Association of Realtors Internet Data Exchange Program, I found 2 listings on that date, October 17th, 2012.
I'm going to show you a copy of the document and ask if you can identify it for me.
Okay.
Can you identify that document?
Yes, I believe this is the information that I had, not this email in the back, but these first 2 pages was information that I had pulled from the internet.
If you can hold on to that, please, and I'd like to pass this out to the rest of the
All right.
commission to look at. And it'll be my next.
Will this be exhibit number 4, I believe?
Pages on this document are what?
Are 2 listings that I found. One was for a property located at 953 Gothic Manor Way, Lot 13, Knoxville, 37923. It says that it's listed by Walter Lane, Benchmark Realtors, and provides a telephone number, which was the same number that I reached Mr. Lane at when I called. The second property that's listed is 1221 Huntington Road, Lot 20, Knoxville, 37919. And below that, it again says listed by Walter Lane, Benchmark Realtors, and provides the telephone number that I spoke with Mr. Lane at.
And what did you do after receiving or finding this information?
Well, because I found it on the open internet and it didn't appear to have a lot of dates, I wanted to make sure that the information was current. So I contacted the Knoxville Area Association of Realtors and spoke with an individual there.
Who did you speak with?
Her name was Donna Roach. It said she was the MLS director.
Did you exchange any email information with Ms. Roach?
Well, I asked her for the information, and she told me that they did have some listings on their MLS, and she sent via email to me copies of the full MLS listings that she had on the Knoxville area MLS at that time.
And what did the listings show?
It was the same two properties, 953 Gothic Manor Way, Lot 13, Knoxville, 37923, and 1221 Huntington Road, Lot 20, Knoxville, 37919. It indicated that the agent, it said owner C. Lane, but it says the listing agent was Walter Lane, and indicates that Benchmark Realtors is on the listing as well. And it had a date of 33 days on the market at that time. And Ms. Roach sent this to me on October 17th, 2012.
Did you have any other communication with Ms. Roach?
When Ms. Roach sent that information to me, I wrote back and I asked her just to confirm that those were the only two listings I had found, but did she mind checking to see if there were any other listings on the MLS system. She indicated that those were the only two showing as active. She also, on the same day, told me that these listings would be withdrawn from the MLS since I had informed her that neither Walt Lane nor Benchmark had an active license.
Can you tell me what the law provides concerning advertising as a licensee if you are not a licensee?
Are you talking about the license requirement in 6213-301?
I am.
The provision of the law at 6213-301 states that it is unlawful for any person directly or indirectly to engage in or conduct, to advertise or claim to be engaging in or conducting the business or acting in the capacity of a real estate broker, affiliate broker, timeshare salesperson, or acquisition agent as defined in 6213-102 within this state without first obtaining a license as a broker, affiliate broker, timeshare salesperson, or acquisition agent. And then it basically goes on to say, unless exempted from obtaining a license.
Were there any exemptions in the law that would apply to Mr. Lane?
The chapter doesn't apply to an owner of real estate with respect to property owned or leased by such person. However, the use of the sign indicated that he was a broker and was affiliated at a firm, and neither of them had active licenses at the time, nor had they for a period of approximately 2 years.
I'm going to ask you your opinion here, and it is just opinion. Would you think that could be misleading to somebody who didn't know he didn't have a license?
In my opinion, if a member of the public were driving by the property, saw a sign with the name of a real estate company on it, the name of an individual, and a telephone number, it would be my thought that the member of the public would believe that that person was licensed.
What did you do with this information then?
I included it in my legal report to the Commission when I presented this matter.
Okay, so this matter, then all this information was included in your legal report and presented to the Commission, is that right?
That's correct.
And after that time, have you had any other, besides the conversation with Mr. Lane in October, have you had any other additional conversations with him?
Only in March to confirm the email address.
And you've had no other communication from him at all?
No.
Did he attempt or try to pay the consent order sent to him, or try to, as far as you know, reestablish himself as a licensee?
He's still in the system as expired. I don't know if he contacted the office, but I was not contacted.
And do you know whether there's been any attempt to revitalize the license firm?
I'm not aware if there has been.
Okay. And do you know or have any other proof to show whether or not, as of today, he is still acting as a licensee by putting signs on property with his name and the firm on it?
I don't have that information. If he is, I'm not aware.
Thank you. I have nothing further.
Members of the commission,
I
questions
have-
for Ms. Crop?
Judge Stovall, I have a question of Ms. Crop. I know I'm a member of the Knoxville MLS, and if you don't pay your dues in July, you can't put any listings in on that blame thing. So evidently, leads me to believe that Benchmark, a.k.a. Mr. Walt Lane, had paid his MLS dues in order, even though his license had expired, his firm license expired September the 8th, 2010. It's my understanding, did you check into whether or not he had paid his MLS dues to be able to put these listings in the Knoxville, the Association of Realtors MLS system?
No, I didn't ask her that because I wasn't aware of the inner workings of the association. I assumed because he was able to add those listings 33 days prior to October 17th that he had access to their MLS and had done so. And it appeared to me that my email to Ms. Roach on October 17th was the first information that they had received that there was not an active license. I'm not sure this is all the information I had from her.
Ms. Cobb, I'll ask you the same question I asked Ms. Maxwell a while ago. When the auditors went to the office to do an audit, is there any notes in there whether there was a realty sign up or indicating whether this Benchmark business was still in business or if he had an office?
I don't receive auditor information unless it's sent to me. That information is down in the TREC office. It's only given to me if it's included as part of a complaint, which it was not here, so that the auditors don't report to me and I don't receive that unless it's part of a complaint file.
Okay, I have another question for you, ma'am. Did you make an attempt to call the Register of Deeds to see whether this man owned both these properties or not?
I looked up the information on the website for the property data assessment sheet, and I believe that information is in the file.
He owns both of these properties.
Can I see the file to confirm what I found? No, it would be a property data. I saw it. It would be.
Did that property? When you where do you get the file?
I'm sorry, it's just been a few months since I've looked at it, so I want to be sure.
Well, I have no problem with that. I want you to clarify who you got the information from, the property data. Did you get it out of the courthouse, or did you get it from some other media?
I received it. I obtained it on the internet. I looked up the information for both of the properties at 953 Gothic Manor Way as well as 1221 Huntington Road. The email address is kgis.org. It's his property map and details report. It's got information about the parcel. The owner information for 953 Gothic Manor Way states that the owner is Candace M. Enos, and it gives an address of 953 Gothic Manor Way, Knoxville, Tennessee 37923. The owner information for 1221 Huntington Road is Candace M. Lane at 1221 Huntington Road, Knoxville, Tennessee 37919.
Indication of where the tax bill went to, the address?
It doesn't say that. It says below the owner information, it says the owner information shown in this section does not necessarily reflect the persons responsible for last year's property taxes. Report any errors to the Knox County Properties Assessor's Office. So,
Slow down.
I'm so sorry.
Go back, does not necessarily reflect the persons responsible for, and I'm,
Or last year's property taxes. It says report any errors to the Knox County Property Assessor's Office at, and it provides a telephone number. I don't see that information on here. It just contains the owner information and address.
There was, by TREC, there was no indications that the data was searched at the courthouse to how the property was recorded in a deed.
I accessed this information on the property assessor's website.
Well, you didn't check the records at the courthouse.
No, sir.
Thank you.
Julie, show me. Put it up there. Okay, somewhere up at the top up there ought to say where, it's usually the first, because I work at our courthouse some. It ought to say where the tax is sent to, when it ought to be in the very first part of it. Now, they may be a little different in Knoxville, but I thought statewide we were pretty similar. Because it will say tax bill sent to this address, but okay.
I don't see it, and there's no page left off because I see in my printout it says page 1 of 1. So it's not that I discarded a second page that
Well, it just may not be on the electronic format then.
It may not be on the copy I printed. I'm sorry.
I think, Ms. Haynes, and you've had lots of dealings with this by owning multiple pieces of property yourself, that a lot of the information that you require off the web is not true and accurate.
Well, actually, the state has now a system where you can pull everything off, or you can go to your individual. Now, there are things like Zillow and all these odd things that I do not trust at all, but there is a state system that apparently that was the state system or the county system. It would be accurate. In most cases, they're within 30 days, at least from what I've researched.
It did say on the property listing from the MLS that the owner was C. Lane, and that appears to confirm what is listed on this report for 1221 Huntington Road. I don't know if that's his wife. He told me that the property was owned by he and his wife. Same last name.
In most cases, I've seen that the MLS differs considerably from what's even on the property record card, but what's property record card is the official, that's the official state of Tennessee card.
Are you aware, Ms. Cupp, that when a piece of property transfers from one individual's name to another, if it transfers in February, it stays in the original owner's name, the tax records, until the next calendar year?
I wasn't aware of that. The information that I found appeared to align with the listing information.
Ma'am, I'm not trying to trip you up. I'm trying to indicate to you that you have not proved to me who the actual owner of this second piece of property is. A point is that this man may have actually owned both pieces of this property. It may have gotten transferred, and the records that you're dealing with would not reflect that because it's in the middle of the year. No problem with it. I'm just indicating what the real facts are.
And that varies from county to county depending on how quickly they get it from the deed?
Don't think so, Ms. Haynes. I think that's, if you go back and check the records, the law has changed, and any tax, any time in a taxable year, whatever, whosever name it is, on January 1, it stays there that entire calendar year.
Yes, excuse me, Commissioner Alexander, Commissioner Haynes, I think that this I would suggest is best for deliberations. What we need to do right now is focus on questions for Mr. Kropp.
I have a question, Mr. Chair, for Ms. Kropp.
No apology necessary.
Ms. Kropp, did you not say earlier that Mr. Lane indicated to you that he only owned one piece of property?
In my notes from the phone call, he said the sign was on property that he owns personally. And that sign, the picture appeared to be from one property. At that time, it was not disclosed to me there are two listings. I didn't have that information at that time to know to ask about it. All I was going on at that point was the photograph. There's a photograph of a sign I have. And I want to know, I'm not sure if this is from when you were licensed. I have no idea. And he said that's on property that he owns personally, and the sign has been up. He wasn't sure if it was up right then, and he wasn't aware it was a problem. Actually, in the return call in the message he left, I have a note that he indicated that was the only property. That's in my notes from that telephone message.
Okay.
Of course, I don't have a recording of that. I'm just going by my notes from October.
Okay. I thought you had stated that
I'm
earlier.
sorry.
Ms. Crop, the property ownership information that you were sharing with us, is that from the Knox County Property Assessor's website?
I believe it is. I went to I have it saved on my bookmark, and I can read you the website address at the bottom, if I can find it. At the top, it says KGIS Property Map and Details Report. I believe the website I have is a link to the property assessors where you click on the county and it takes you to the individual page. I don't see that that's at the top, but it appears to reference the Knox County Property Assessor's office on it, and I believe that's what it is here.
Brian, excuse me, I think probably we should make that an exhibit. Is that what you're going to do?
Yes, Your Honor.
And let's mark that as the next numbered exhibit, and then
I have copies
pass
of all,
that
but I'll be happy to pass.
pass that to the commissioner for their review.
And court, please, I also don't have copies of the MLS,
Ms. Ryan, would you hand that to me first? Let me mark that, and then we'll pass it around. No, that's all right. This will be number 5.
I still, Your Honor, I have a question for Ms.
Hang on, Mr. Alexander.
This is MLS.
Thank you, sir.
Oh. It's like if a searching for the MLS.
All right, the number 6.
No, this is MLS.
Passing these documents around at this, do we have any other questions for Ms. Crop pending your review of these exhibits? Go ahead, Mr. Alexander.
In essence, you're not sure which piece of property this sign was sitting on, are you?
I don't know which piece the property was listed on, but I do know he had both of them listed on the MLS.
But you don't know whether it was two signs, whether it was a sign on one property or two, were there two signs out or one?
I don't know that information.
You don't know which property that sign was on?
I don't.
Thank you, ma'am.
Quickly want to point out it was just last updated 10/1/12. I don't know if anybody else caught this in here because the exhibit number was kind of over the top of that.
Are you talking about the property data?
Yes.
Yeah, I had pulled that on the 17th, so that I'm assuming.
But you don't. Okay.
I pulled that on the same day as I received other information.
Ms. Crop, in looking at these two exhibits, one is to Candace M. Enos and the other one's Candace M. Lane. Is it a possibility that that's his wife that owns both those pieces of property?
That's a possibility.
I'm looking at two pictures on MLS, and I'm looking at the picture of the sign, and they aren't any three alike.
I have two pictures, and to me it looks like one is more zoomed in than the other. It looks like the same brush behind it. So to me it looks like the photo of the same sign, just further away and up close.
But it's different windows. This one has a dormer. It looks like this one has siding. These are both brick. Does it say brick?
I don't think it matters.
Let's see. See if it says brick on here to you. I'll read this one. It should say brick.
I guess I'm a little confused here, and I'm not sure if I need to direct this at Ms. Crop or Ms. Ryan. The point
That's not brick.
Is not which piece of property it's on, but the fact that he's using a benchmark sign rather than a for sale by owner sign. Am I on the right page here?
Appeared to me that this individual was advertising as if he was an active licensee under an active firm, when that in fact had not been the case for approximately 2 years, and it was even listed on the MLS that way.
So regardless of whether he owned the property or not, we still have the issue of him using a company sign that was not a licensed business.
It was expired at that time, as well as his own broker license.
Thank you.
My question is, we still don't have any evidence that the sign, the picture of the sign that was sent to us, I mean, I understand that the MLS, yes, but the sign picture that was sent to us, we have still don't know when it was taken or even the address that is associated with it.
And mine is ours. Ms. Crop, didn't you have a conversation with Mr. Lane about the sign? And did he say that the sign was in front of a home at that time?
He said that he wasn't sure if it was up right then, but it had been up recently. He didn't give me the address. Like I said, when we spoke, he was quickly trying to get off the phone, telling me he was in a meeting.
Anything else from Ms. Crop? No? Thank you, Ms. Crop.
Oh, wait a minute.
I'm sorry, Ms. Ryan.
That's okay.
Ms. Ryan.
I have a few questions
I
for you.
I forgot about
okay.
you.
Ms. Crop, this was originally an anonymous complaint, and you didn't take it at that, did you? You just didn't go with just the signs on the pieces of property.
I tried to get more information.
And that's when you looked up the property itself listed in Knox County after you discovered the advertisements?
I looked to see who the owner was, and I researched the listings on the internet, and then I contacted the association.
And then also, in these particular documents that we presented earlier, you indicated that, and I wanted to be sure that it is saying that it's listed by Walter Lane with Benchmark Realtors. Is that right?
Right, and the MLS listings that Ms. Roach provided me indicated the same thing.
And listed Walter Lane. Is that right?
It said Walter Lane on there.
Okay, at Benchmark Realtors.
It said Benchmark on there.
Now, is there a law in place right now that provides that if you are unlicensed or previously licensed with an expired license and worked for a firm that was previously licensed but now expired, that you indeed can advertise for sale property whether you own it or not with that signage?
Well, 301 prohibits advertising or claiming to be engaging in conducting the business of being a broker without a license, and to me this appeared to be advertising through a sign, regardless of where it was, and through the MLS listing, which stated him as the agent and the firm.
And all this information was presented to the commission, right? Is that right?
It was summarized and presented anonymously, yes.
And the law does not provide, again, that you can advertise if you're not a licensee. In fact, it prohibits that. Is that right? It says you cannot hold yourself out basically as a licensee if you do not have a license. In fact, let me direct you again to 6213-301.
Right, it states that it's unlawful to, among other things, advertise or claim to be engaging in conducting the business or acting in the capacity of a broker without a license.
When you looked up the documents from the Knox County, you were directed there by initially going, I'm asking, and I'm assuming this, and you can correct me if I'm wrong, by initially going to the Knox County website to get that information direction to the property assessor's office?
I think it was a statewide site where you can click on the county, and I clicked on Knox County.
So this is information to you provided by the state, then?
I believe so.
Thank you. And last fall, I'm going to reiterate again, when Mr. Lane called back, he did not indicate to you that he owned 2 pieces of property, but he said in his message that he owned 1 piece of property. Is that right?
In my notes, it said that this was the only property that he and his wife owned.
But instead, there are 2 listed with his name on it. Is that right?
There were 2 listings provided to me.
Thank you. I have nothing further.
Ask one more question. Yes, sir. Who owned Benchmark Realty? Who was the license in?
I don't have that information. I know he's the principal broker.
I would be happy to call Ms. Maxwell back for an answer to that question. She would be the person that would have that information.
He was the principal broker, but I know that wasn't your question, right? That wasn't your question, that he was the principal.
Didn't answer my question, no.
Okay.
Anything else from Ms. Crop? No? Thank you, Ms. Crop. Other witnesses, Ms. Ryan?
No, but I'd like to call Ms. Maxwell.
Ms. Maxwell.
Let me start with Ms. Maxwell. Who at all time was listed as the principal broker for Benchmark?
Walter R. Walt Lane.
Does your information in your file indicate who the owner, if there was an owner outside the principal broker for Benchmark Realty?
File, this is Mr. Lane's personal file, indicates that he was the principal broker. It doesn't indicate there was another owner or not.
You would not necessarily have that information, would you?
No, we would not. You do not have to be a licensee to have a firm, to own a firm.
Now let me go back and ask a question about process, if I might, which might clear up some other questions. When an anonymous complaint is filed, are you allowed to immediately throw it in the garbage?
No, we are not. We are to open every complaint that comes in, whether it's anonymous or not.
So based on the information you had, you then presented it to legal department. Is that correct?
That is correct.
And then the legal department, she took it on herself to make sure there was other information to present it. Is that correct?
That is correct.
So you don't have the information from the MLS listings or from the listings that were on the Knox County site in the original complaint?
No, and the original complaint came in a plain white envelope with the pictures, with no identifying information as to the sender whatsoever.
And let me ask you a question. Has this commission heard issues of this in the past, and I don't know the answer to this question, about whether or not a licensee is entitled to continue advertising using previous signs when they're no longer licensed? Has that come before this commission before?
Not to my knowledge, but it could have come before them. Not to my knowledge, though.
Okay. But are you also a lawyer, Ms. Maxwell?
Yes, I am.
And did you also practice in real estate?
Yes, I did.
Is it your understanding that as a licensee, you could advertise property that you own using an expired firm license sign?
No, that is not my understanding. That would be my understanding. That would be a violation of the Broker Act.
Thank you. I have nothing further.
I have a question.
But I have a question. Go ahead, Ms. Alexander.
Ms. Maxwell,
Yes.
how many agents did Benchmark Realty have other than this individual?
Throughout the time frame?
At the time
or-
of the complaint or whenever?
At the time the firm expired, it showed that it had one person, Laura Dean Copeland, license number 315825. She is no longer, she's reflected in the history of the firm.
Did she transfer her license or is she still active?
I don't know whether she is still active. She just shows up in the, she would, when you look up the firm, it initially will flash on that it's not eligible to have licensees, but then it'll show the history that she was a licensee.
So you, in fact, then are not sure whether at the time of this infraction, whether she was still associated with that firm?
I do not know whether she was licensed, whether her license had expired, whether it was active. I don't know.
Ms. Maxwell.
Yes.
You stated that the picture of the sign came in a plain white envelope. Was there any verbiage at all with the sign?
No.
Why at that point then would you assume that it was unlicensed activity?
Because we did look, we looked up and the license was expired and the firm license was expired. And so we sent the individual a cease and desist. And the cease and desist gives the individual an opportunity to, it says we have information that you may be in violation of engaging in an unlicensed activity. And so that gives the person a chance to respond to us and say, no, I'm not, or yes, I am, or I didn't know, or it just gives them an opportunity to answer the cease and desist.
You made no effort to determine whether or not the sign was current or whether or not it was on an active listing it was just a matter of giving them an opportunity to respond to something that was submitted anonymously?
Normally, we try to find something on a website so that if we got a notice of unlicensed activity from someone, say, who had never been licensed, and you could Google it and it would come up, then we would go to their website and copy the applicable information. In this situation, it was a former licensee who was expired at that point in time, and the firm was expired, and so we sent them the cease and desist, and that person would be given an opportunity then to tell us whether they were or were not licensed, or whether there was something amiss with the sign. So that would give them an opportunity to address the issue.
Thank you.
Thank you, Ms. Maxwell.
I have nothing further. I would like a close.
Closing. All right. Go ahead, Ms. Ryan.
I submit to you it matters not whether Mr. Lane owns these property for the deeds he did. He had listed in MLS properties for sale from Benchmark Realty in his name. The reason the state of Tennessee has laws concerning licensees is, of course, to protect the public. When the public is faced with something like a real estate sign listing a person's name and a firm, the public should have the right to believe that that person is properly licensed. Your laws, specifically the laws provided in 6213, and I'll give you the exact number, 301 state, it is unlawful for any person, directly or indirectly, to engage in or conduct or advertise or claim to be engaging in or conducting the business or acting in the capacity of a real estate broker, affiliate broker, etc., without having a license. The proof today is that Mr. Lane had a license, but it expired 2 years previous to these specific instances. Moreover, the firm license had also expired, and what was being presented to the public, whether on that sign or whether on the MLS, was that there was a reason to believe that there was a licensed firm and individual offering properties for sale. I submit to you that's a violation of your laws, and I'm asking you to assess a civil penalty. To make that a consideration in your finding today, if Mr. Lane chooses to come back before you, that the law also provides that once there's a finding you can, of a violation of the law, you can have him come back before you if he wishes to come back and pursue a license, and that he be required to pay all of the court costs in this matter. Thank you.
Brian, do you have a proposed order?
I do. I've had proposed findings of facts and conclusions of law.
Proposed findings of fact, yes, ma'am. And do you have in your proposal, is it set out the range? Or are you requesting a specific civil penalty?
I'm not requesting a specific set. I can direct them to.
Since as I stated earlier, since I'm doing this on the fly today and didn't bring all of my laws with me, could you or the member of the staff advise what the range is for the
Ms. Kropp can do that. She's got the. Yeah, go ahead, Julie.
Could you do that?
Julie, just give the range for that. It's 301.
That's right. If you want to go ahead and pass that out to the board while Ms. Kropp, could you do that for me, please, Ms. Kropp?
Would you like a copy of
That
this?
would be even better.
Judge, what was the range on that penalty, please?
I'm going to get to that when I give you my charge, Ms. Chair. All right. Members of the board, if you'll bear with me for one moment to give you a very brief charge, and then I will turn this over to the Commission to conduct your deliberations. It's your responsibility at this time to make a decision in this matter, and this decision will be the final order in this case. The final order will contain findings of fact, conclusions of law, and a determination as to what, if any, penalty is appropriate should you determine that the respondent has violated any provisions of your statutes and or rules. There's also, that order must contain the policy reasons for your decision. The burden of proof is on the state to show by preponderance of the evidence or as the more probable conclusion that the factual allegations contained in the notice of hearing and charges are true. The burden of proof is also on the state to show by that same preponderance of the evidence that the factual allegations that you find to be true constitute a violation of the statute and or rules as is set forth in the notice of hearing. Ms. Ryan has provided to you a document entitled Proposed Findings of Fact and Proposed Conclusions of Law. This sets out what the state believes it has proven in this case. The Commission is free to use this. The Commission is not to consider this document to be evidence, but the Commission is free to use this in any way it wishes to guide you during your deliberations, and you may adopt the the proposed findings in their entirety or make whatever modifications you deem appropriate based upon the evidence that you find to have been proven in this case. Should you determine by your findings of fact and conclusions of law that the respondent, Walter Lane, has violated the statute and or rules as is set forth in the notice of hearing and charges, in this case the department is requesting the assessment of civil penalties and the costs of this proceeding against Mr. Lane. You are authorized by statute and rule to assess both costs and civil penalties. As I read your rule 1260-2-.32, paragraph 2, with respect to any person who is required to be licensed and is not licensed in this state, the civil penalty is $1,000 per violation for a violation of Tennessee Code Annotated 62-13-301. As I stated earlier, the decision on the merits of this case is left to the Commission, and I will not participate in your deliberations. However, I will be available for any questions that you might have of me during the course of those deliberations. And again, your decision must be based only upon the evidence that was produced before you this morning. If you don't have any questions of me at this time, I will turn over to the chair to conduct the deliberations.
Judge, I have one question.
Yes, sir, Mr. Northern.
The date of the penalty assessment, proposed penalty assessment, does it show what date that was adopted?
This appears to be a recent amendment, and correct, Ms. Kropp, can you, or actually, I guess, Ms. Ryan, it says March 3, 2013. Do you know whether or not did that civil penalty change prior to March 13?
That was the date of the effective date of
an amendment.
Well, what happened was they were misnumbered. And the previous one prior to that was still $1,000. But what happened was they were off kilter, and so that's why.
All right. So that the civil penalty of $1,000 for violation of the statute is the same as it's always been.
That's correct.
Okay. Does that answer your question, Mr. Northern?
Yes, that's one of the three that we corrected some months ago. Okay.
Go ahead, Mr. Chairman.
Commissioners, you have heard the testimony. You've heard the charge from the state, charge from the judge. It's our turn now to deliberate and determine what we feel is appropriate in this matter of Walter Walt R. Lane. Does anybody have anything they would like to say at this time?
Mr. Chairman,
Mr. Alexander.
At this point in time, I am not convinced where the sign was placed, whether it was sitting beside some office building and where it was. At this time, I'm not convinced who actually owned the property. I really think it's probably owned by this individual. The state has not told me who owned the real estate company, but it appears that he was the principal broker, that there probably was only one agent. The burden of proof has not convinced me that we knew all the facts.
I'm not really concerned about what piece of property it was on. The fact of the matter is that the sign was out there. It indicated it was Benchmark Realty. Even if he owned the property, it should have just been a for sale by owner sign out there, not a Benchmark Realty sign. His license was expired, and so was Benchmark's. So he was practicing without a license, regardless of what property it was on. It was on the MLS that showed it was Walt Lane, Benchmark Realty, and it was on the internet that showed Walt Lane with Benchmark Realty. So it really doesn't matter where the sign was, in my opinion. He was advertising that he was associated with an expired firm and indicating that it was an active company.
Yeah, there's two things we do know. We do know that Mr. Lane's broker license expired December the 17th, 2010, and his firm license expired September the 8th, 2010. And there were two listings in the Knoxville MLS as late as 2012, approximately almost 2 years after the firm and his broker's license expired. Other than that, just like this sign, I mean, that picture could have been made 5 years ago in front of another house. We don't know that. But those three things, I think that we do know that is in fact true.
You ready to consider findings of fact?
Yes, Commissioner McMullen, we are.
I'd like to make a motion, if I could, Mr. Chairman, that we make the following finding of fact: that the respondent was at all times pertinent hereto, unlicensed with the Tennessee Real Estate Commission, respondent's broker license number 25058, having expired on December 17, 2010.
I'll second that.
We have a motion by Commissioner McMullen read into the record and seconded by Commissioner DeShara. Any discussion on this motion? All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman?
Yes, Commissioner McMullen.
Move that we make the following finding of fact: respondent was formerly the principal broker of Benchmark Realtors, a formerly licensed real estate firm with the Tennessee Real Estate Commission. The firm license number 60094 expired on September 8, 2010.
A second.
A motion and a second, which Commissioner McMullen has read into the record. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following finding of fact. On or about June 2012, the Tennessee Real Estate Commission received information that respondent was utilizing a yard sign advertising the sale of a property. This yard sign included respondent's name, the name of respondent's expired firm, Benchmark Realtors, and a telephone number.
Second.
Call for roll call vote. Commissioner Northern.
I've not heard any evidence that says that this sign, at the time his license had expired, was in fact found to be on a list on property.
If I could just speak to that, I heard Ms. Kropp testify that whenever she talked on the phone to Mr. Lane, he admitted to her that the sign was on property at or about that time that was listed for sale.
Well, unless you're looking at a picture, they were on a telephone call. I mean, somebody could call me and say, is there a sign on the property? Oh, I've got signs on lots of properties. I mean, I don't know unless I'm looking at it. I don't know that this picture is legitimate.
Well, but if you only have 2 properties listed, you know whether you've got a sign on 2 properties or not.
Well,
and if you don't have a license.
Yeah, especially if you don't have a license.
Any other discussion on this motion?
Oh.
Mr. Chairman, I call for roll call.
Roll call vote. It's been called for.
And the motion is...
The motion is on or about June 2012, the Tennessee Real Estate Commission received information that respondent was utilizing a yard sign advertising the sale of a property. The yard sign included respondent's name, the name of respondent's expired firm, Benchmark Realtors, and a telephone number. That's the motion that was made and has been entered into the record and duly seconded, and that's what we've discussed.
Mr. Chairman, could I make one comment on this just to clarify? As I read this, what the proposed fact is that these things occurred Now, whether or not that's a violation of the law or not is a different question, and that's ultimately what you all need to decide. But as I read this, it's merely saying that in fact the Real Estate Commission received this document with these photographs, with this information on it. Now, that may or may not be a violation. You all need to decide that. But I want to make sure the commissioners understand the distinction between those two. Do you follow me? Before you vote? Okay. Thank you, Mr. Stevens.
Alexander?
Oh.
Collins?
Yes.
DeChara?
Yes.
Grease? Oh, he's gone. Flitcroft? Oh, he's abstained. Haynes?
Yes.
McMullen?
Yes.
Northern?
No.
Stevenson?
Yes.
So it's, there's 5 yeses and 2 noes, and 2 abstentions, I guess.
Mr. Chairman, I move that we make the following finding of fact. Information obtained from the Knoxville Area Association of Realtors on October 17, 2012, showed that respondent entered listings for the sale of 2 properties located at 953 Gothic Manor Way, Lot 13, Knoxville, Tennessee 37923, and 1221 Huntingdon Road, Lot 20, Knoxville, Tennessee 37919, on the multiple listing service 33 days prior to October 17, 2012, on or about September 14, 2012.
Second.
Have a motion by Commissioner McMullen, seconded by Commissioner Northern. You've heard it read in the record. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following finding of fact. These 2 listings included respondent's name as the listing agent and also included the name of Benchmark Realtors, respondent's expired firm.
Second.
A motion by Commissioner McMullen and seconded by Commissioner DeShara. Read into the record this motion. Any discussion on this motion? Hearing none, all in favor say aye.
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 Opposed, no. Motion carries.
Mr. Chairman,
Commissioner McMullen.
I move that we make the following finding of fact. Records of the Knox County Property Assessor, updated October 1, 2012, indicate that the property at 953 Gothic Manor Way, Lot 13, was owned by Candace M. Enos.
Second.
Motion made by Commissioner McMullen, seconded by Commissioner DeShara. You've heard it read into the record. I'm not going to restate the motion. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following finding of fact. Records of the Knox County Property Assessor, updated October 1, 2012, indicate that the property at 1221 Huntingdon Road, Lot 20, was owned by Candace M. Lane.
Second.
I have a motion by Commissioner DeShara. It's seconded by Commissioner DeShara. The motion is made by Commissioner McMullen. You've heard the motion read into the record. Any discussion? Hearing none, all in favor say aye.
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 Opposed, no. Motion carries. You're going to abstain. Let the record show that Commissioner Alexander abstained from the vote on this motion.
Mr. Chairman, I move that we make the following finding of fact. The MLS listings list C. Lane as the owner, Walter Lane as the listing agent, and Benchmark Realtors as the listing firm.
Second.
Heard the motion made by Commissioner McMullen and seconded by Commissioner DeShara. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
On to conclusions of law, unless somebody else has some facts.
Anybody else have any findings of fact based on the testimony in this case that you would like to read into the record and put on the floor in form of a motion concerning any of the testimony we heard? Hearing none from any commissioners, we move on to the proposed conclusions of law.
Mr. Chairman, I move that we make the following conclusion of law. Respondents' acts and conduct constitute two separate violations of Tennessee Code Annotated 62-13-301, which states, "It is unlawful for any person, directly or indirectly, to engage in or conduct, to advertise or claim to be engaging in or conducting the business or acting in the capacity of a real estate broker, affiliate broker, timeshare salesperson, or acquisition agent, as defined in Section 6213-102 within this state, without first obtaining a license as a broker, affiliate broker, timeshare salesperson, or acquisition agent, as provided in this chapter, unless exempted from obtaining a license under Section 6213-104.
Heard the motion concerning the proposed conclusions of law by Commissioner McMullen and seconded by Commissioner DeShara. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move we make the following conclusion of law. Rule 1260-2-.32, paragraph 2, provides that with respect to any person required to be licensed by the Commission as a real estate broker who is not licensed, the Commission may assess a civil penalty against such person for each separate violation of a statute in accordance with the following schedule. TCA Section 62-13-301, penalty $1,000.
Second.
Motion read into the record made by Commissioner McMullen and seconded by Commissioner DeShara. Any discussion or comments on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following conclusion of law. The Tennessee Real Estate Commission is authorized to assess the cost of investigation and hearing costs pursuant to Tennessee Code Annotated Section 56-1-311 and Rule 0780-5-11-.01.
Second.
Motion made by Commissioner McMullen, seconded by Commissioner DeShara. Any discussion? All in favor say aye.
Aye.
Opposed, no. Motion carries. Anybody have any other proposed conclusions of law that they would like to read into the record and make a motion on? Hearing none, at this time, it's our duty to determine, based on the findings of fact, the conclusions of law, as to whether or not there's any assessment of any penalty or any other matters we want to take into consideration in this matter.
Mr. Chairman, I move that we assess a civil penalty against Walter R. Lane in the amount of $2,000 plus the cost of investigation and hearing costs.
I'll second that.
We have a motion made by Commissioner McMullen that we assess a $2,000
Mr. Chairman, I call for roll call.
Civil penalty, and also the assessment of the cost of this proceeding. Any discussion on that motion?
I'd like to see it reduced to $1,000.
Would you like to make that a friendly? Would you like to make that an amendment?
I would.
We have an amendment. It's been entered into the record for the civil penalty to be reduced from $2,000 to $1,000. Do I hear a second on this amendment?
I second the amendment.
The amendment has been seconded by the motion was made by Commissioner Collins and seconded by Commissioner Northern. Any discussion on the amendment? Hearing none, I would like to ask Ms. Maxwell to call the roll on the amendment.
So this is the amendment just reduces the 2,000 civil penalty to 1,000 plus the cost of the hearing and investigation. Is that correct?
Correct.
The amendment, Alexander,
I'm going to abstain.
you're going to abstain? Collins,
For the motion. I'm sorry? For the motion.
DeChara,
No.
Reese, Flitcroft, Haynes,
For the motion.
McMullen,
No.
Northern,
For the motion.
Stevenson.
Yes, for the motion.
So the amendment gets 4 yeses and 2 noes and 1 abstention and 2 individuals who are not participating.
Now, we're going to vote on the motion made by Commissioner McMullen as amended.
Call for roll call.
A roll call vote again.
Okay, so this will be that the civil penalty will be $1,000 plus the cost of the hearing and investigation. Is that correct? Okay.
Correct.
Alexander,
No.
Collins,
Yes.
DeChara,
Yes.
Grease, Flitcroft, Haynes, McMullen,
Yes.
Northern,
Yes.
Stevenson.
Yes.
So there are 6 yeses and, 5 yeses and 6 yeses and 1 no, and then 2 individuals who didn't participate. So it's a $1,000 civil penalty plus the cost of the hearing and investigation. This was amended, so that's.
And I'd just like to say, the cost, if I could, Your Honor, to address to Ms. Ryan, approximately the cost of these proceedings.
Unknown.
Stevenson, you could, and I say, I don't recall whether or not it's in your statute. I know it is in the statute for the health-related boards. Are you required to have a cap on the cost?
No, we're not.
All right, I know, but you, if you wish, Mr. Stevenson, you could cap the cost.
But let me explain to them what it
Go ahead.
covers right now. We traditionally don't, even though we're entitled to, we don't charge for attorney's time. And we have traditionally not charged for investigation time, which this time would have only been limited to the auditor. So the costs that we're looking at are the cost of the judge and the court reporter. And that's why I don't know how much it will be, because it depends what they're come up with at the end of the day.
Well, I make a motion we limit it to those 2 people then, to be the court cost.
We'll put that in the form of a
I just
motion.
did.
Okay, I'm sorry. We have a motion entered into the record by Commissioner Collins that we limit the cost in this proceedings to the cost of the judge, Stovall, and the court reporter.
Second that motion.
And I have a second to that motion by Commissioner Alexander.
Mr. Chairman, could I let me just for the record, you don't put my name in there. Put the administrative judge.
The administrative-
the costs of the administrative judge, because actually there's been 3 people involved in this case.
Okay.
All right.
The cost of the administrative judge.
There you go.
Okay. Yeah, amend that. Yeah, we'll change the wording on that.
Oh, see, Jude.
Any discussion on this motion made by Commissioner Collins, seconded by Commissioner Alexander? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously. Now, we have determined the findings of fact, we have determined the conclusions of law, we have determined what we feel the penalty should be in this matter, the appropriate penalty should be. Now it is our duty, and we have been charged with finding and establishing and putting in the record a, what's that word? A policy statement. I've seen your moment there for a minute. A policy statement. Would anybody like to read into the record a policy statement that they feel would be appropriate in this matter?
I don't have one to read, but I'll make one up. Mr. Chairman, I move that we adopt a policy statement stating that it is the policy of the state of Tennessee to require licensure of individuals who are advertising or claiming to be engaged in the business of being a real estate broker, and that policy is intended to protect the public and to provide them with information that's accurate. In this situation, the accused, Mr. Lane, violated that requirement, and therefore the imposition of a civil penalty on him was appropriate in order to continue to protect the public.
I hear a second.
Second.
We have a policy statement that's been read into the record by Commissioner McMullen and seconded by Commissioner Northern. Any additions, corrections, or comments on this policy statement that's been read into the record by Commissioner McMullen? Hearing no comments, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously, and
adjourned in this proceeding.
I think we're finished, Your Honor.
Sir.
We stand adjourned.
Yes.
It is time for lunch.
Where do we want to go?
It's 12 o'clock. We have another formal hearing at 1 o'clock.
We do. Judge, I don't know if they'll get back quite on time, 1 o'clock. I just wanted to tell you that.
Well, I was going to ask, does the commission have any other business, or is this the only thing you have in the afternoon?
This is it.
Okay, all right. So if you give me a little latitude, because I'm going to have to run back up the hill.
Well, they wanted to.
You are going to have me this afternoon. I got to go get the file and come back and so on.
Your Honor, we can't start till you get back, so don't rush.
All right. Okay.
Don't break your leg going up the hill.
Okay. All right.
What you need?
Yeah, why don't we just say 1:30?
1:30?
That gives me plenty of time.
Yeah, that's fine.
What'd you say, Steve?
You can bring lunch, too.
Stay or can they go?
Hey.
I think they need to.
For the ones that are here by consent order to have to stay.
I'm not going to make this decision.
Been making it for months.
Well,
You get the big bucks for it.
I'm going to ask if anybody on this commission wants to make a comment or a motion as to what we do with our attendees at this time.
I have a question, Ms. Ryan.
We addressed that yesterday. You remember what the conversation was yesterday?
They stay as long as we stay.
If they're here under consent order.
I have a question of Ms. Ryan. Do you know whether or not this afternoon's case is contested? I mean, with attorney, rather?
I have heard nothing from the attorney, and nothing from, although I had one conversation with him, nothing further after that conversation with the respondent. But as you well know, like last month, sometimes attorneys and people show up regardless.
Can I ask a question?
Yes, you may.
There seemed to be a discrepancy about what time the trial was with the judge.
No, there isn't. I had two separate notice of hearings filed. This one was stated as starting at 9 a.m., and the one for this afternoon is stated as starting at 1 p.m.
That was
In
our
the
mistake.
notice of hearing.
That was our mistake.
Oh,
That was our. We thought both. I say we. Judge Safley thought both cases were at 1.
I just hope the person we were supposed to be trying didn't think it was at 1.
No. The notice says 9 o'clock.
Now, we still have an issue before this commission as to whether or not we want to require these attendees, the ones who are here, for the ones that's got an A after a name, which is 2, would stay the full time. That somebody want to make?
Mr. Chairman, I have a motion.
What is it?
I move that all attendees be allowed to leave.
I second that motion.
The reason for that is it's traditionally understood that the commission the second day leaves about noon.
I think to that end, they were here for 6 hours yesterday. They've been here this morning since 9. It's 12 o'clock now. They've gotten set in on 9 hours of classroom and.
Call for the question, Mr. Chairman.
Be allowed to leave also.
We have a motion by Flitcroft. We had a second by who? Collins, any discussion on this motion to let these attendees leave now with the exception of those
No, there
two?
wasn't any exception.
There wasn't any exception.
No exception. That mean let them all leave?
I want to amend that to the ones that are here on consent order stay, since their consent order says they stay for the entire meeting.
Okay, we have an amendment to the motion made by Commissioner Flitcroft. And have a second. The amendment was made by Commissioner DeShar and seconded by Commissioner Haynes. Any discussion on the amendment? Hearing none, all in favor say aye.
Aye.
Now, we're voting on the motion as amended, which is to allow all of the...
Where are you going to say all those opposed?
Wait a minute.
All opposed, I'm sorry.
I oppose.
Okay, all of those who say oppose, no.
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 We got 2 noes,
Okay.
1 abstention, and 6 yeses. Now, we got to vote on the amendment, on the motion as amended to let all the attendees leave with the exception of the ones that are here by a consent order. All in favor say aye.
Aye.
Opposed, no.
I don't understand the question.
The 2 that are here because they have to be
I
here
thought
on
we already let
consent.
them go.
No.
Everybody except the 2. that are
Everybody,
on
the one,
consent order.
except the 2 for the consent order.
These women are hard, bro.
The motion carries.
I'm voting no.
We got 2 noes, 1 abstention.
You got to find out.
You got to sign out before you leave. Sign out. We have 6 yeses, 2 noes, and 1 abstention. We hope what you have learned will be beneficial to your career.
Parliamentary procedure wasn't one.
Respondent is here.
All right. Everybody ready? Call this Real Estate Commission meeting back into order. And on our agenda this afternoon, we have a formal hearing, Tennessee Real Estate Commission versus Jeffrey Hale, docket number 12-18-1201-49A, complaint number 2012-010-721. And at this time, I think I'm going to turn it over to our judge, Tom Stovall.
Thank you, Mr. Chairman. Mr. Hale, are you Mr. Hale? I am. You want to step forward and sit right here, sir? Right. Ms. Ryan, do you have a copy of the notice of hearing and charges
I do.
for the commission? Members of the commission, I'm going to ask at this time for Ms. Ryan to pass a copy of the notice of hearing to you for your review. And then,
I was going to ask Judge Stovall if you could, that microphone.
are we on now? Are we on now?
Yeah, we're fine. If the little red thing's on, it's on.
Got it. Okay. No, I've got it right here. We'll stand in recess for a moment to allow the commission members to review the notice, and once you have read the notice, we will formally open the proceedings.
Welcome, man.
Thank you.
Mr. Chairman, it appears that most of the commission members have had an opportunity to review this notice, so we will now formally open the proceedings. This is a hearing before the Tennessee Real Estate Commission to consider the matter of Mr. Jeffrey Allen Hale, license number 317970, as a result of the notice of hearing and charges filed February 21st of 2013. This notice has been passed to the commission for its review. My name is Tom Stovall, and I have been assigned by the Secretary of State to be the administrative judge at this hearing. As the administrative judge, I do not participate in the decision that's made on the merits of this case. That decision, of course, will be made by the members of the commission that are present this afternoon. Would the members of the commission that are present this afternoon please identify themselves for the record?
David Flitcroft.
Robert Collins.
Janet DeChara.
Bear Stevenson.
Michelle Haynes.
Isaac Northern.
Austin McMullen.
John Grease. Wendell Alexander.
Thank you. Members of the commission are reminded that their decision in this matter must be based only upon the record that's produced during the course of this proceeding this afternoon. Failure to abide by this instruction could result in the matter being reversed or remanded back to the commission for further consideration should it be appealed to Chancery Court. I would ask the commission at this time if any member of the commission has received any ex parte communications concerning this matter, or now that you have reviewed the notice of hearing and charges, if you have any prior knowledge about the facts of this case or familiarity with the respondent, Mr. Hale, or have any other reason to believe you should disqualify yourself from this proceeding. All right, seeing none. As I stated, the record consists of the notice of hearing and charges, a pre-hearing order that was entered in this matter by Administrative Judge Joyce Safley on March the 18th of 2013, and the department's witness and exhibit list filed March the 20th of 2013. Ms. Robin Ryan, Assistant General Counsel with the Department of Commerce and Insurance, represents the department in this matter. Record also show that Mr. Hale is present this afternoon and not represented by counsel. Mr. Hale, did you understand that you had a right to have a lawyer with you today?
I did.
And you want to proceed without counsel, is that correct, sir?
I do.
All right. Ms. Ryan, do you have an opening statement you want to make?
I do.
All right.
I believe this will show itself to be a very simple matter. The proof will show that Mr. Hale has a license, number 317970, and that this license is not set to expire until July of 2014. The proof will further show that until August of 2011, he was affiliated with a real estate firm in Chattanooga, Tennessee. And around that same time, the proof will show he was released. And because of his release, the proof will show that Trex sent him a letter concerning that release and reminding him of the fact that he had 10 days to either transfer or retire the license. Proof will show that not until May of 2nd of 2012 did he attempt to affiliate with another real estate firm in Chattanooga some months later? Because of that 8-month delay, proof showed that the Office of Trek sent an agreed citation concerning the failure to take the 10-day administrative steps within 10 days, and that agreed citation was signed for on or about May 12th of 2012. Proof will show that this respondent has done nothing, that he did become affiliated with a new firm in May of 2012 on or about, but that he has not addressed the 5 or 8 month delay, and that he has not paid the proposed agreed order, nor answered this complaint for that matter, and that the license now is listed as inactive, which means he could not retire. Proof will show again that this license will expire in July of 2014. What I was asking for today is that this commission consider suspending the license until the respondent addresses that particular violation, pay any civil penalty that you might assess, and then all the court costs of the matter, at which point the license would be reinstated. And that's what we're seeking to.
All right, Mr. Ryan, you'll have Mr. Hale, you'll have an opportunity to fully explain your side of this case later. Do you want to make any brief opening statement to the commission at this time, or do you want to simply allow Ms. Ryan to go ahead and put her witnesses on? You'll have an opportunity to question those witnesses as well.
No, I'll say what I need to say when.
All right. Ms. Ryan, you want to call your first witness, please?
I'll call Eve Maxwell.
Right hand. Solemnly swear or affirm the testimony you give in this cause will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do.
Ms. Maxwell, will you state again your full name for the record?
Eve M. Maxwell.
What is your position?
I'm the Executive Director of the Tennessee Real Estate Commission.
And as that director, are you familiar with both the licensing file and the complaint files of Mr. Jeffrey Hale?
Yes, I am.
And what is Mr. Hale's license number?
His license number is 317970.
And when was he first licensed?
Mr. Hales was first licensed on July 11th of 2008.
And do you have so he was licensed July 11th, 2008? And the current status of his license?
His license is currently in an inactive status. He filed a TREC 1 on September 13th of 2012 to retire his license, but he was short education, and he still continues to lack 3 hours of education, which must be completed prior to his license being retired.
And when is the license, again, is set to expire?
His current expiry date is July the 10th of 2014.
How did this complaint come about?
Mr. Hale was affiliated with a firm, and he was broker released on 8/17 of 2011. And at that time, he was sent a letter on 8/19 of 2011. He was sent a letter that told him his license had been broker released and that he had 10 days in which to retire his license or affiliate with another firm. And he did not respond to that. He did not find another firm. And when he did find another firm, on May the 2nd of 2012, at TREC, what we do is when someone has been broker released and then when they try to transfer to a new firm, if it's been over the 10 days, the licensing tech will bring the TREC 1 form to Mr. Connell House, who's our complaint coordinator, and he will then send a citation for failure to complete administrative measures. And in this case, that's what happened. A citation was sent to Mr. Hale for failure to complete administrative measures as required in Rule 260-02-.02.
And did you hear from Mr. Hale after that time?
We did not hear from Mr. Hale. He did not respond to the citation which was sent by TREC.
What happens after there's no response to a citation?
If there's no response to a citation, then it runs the regular complaint process, which is that goes up to legal, and then legal reviews it at the appropriate time and presents it to the commission.
Okay. And then after that fact, has anything happened with Mr. Hale's license since the presentation, or after he became affiliated in May of 2012?
After he was affiliated in May of 2012, he was then broker released by that firm on September the 12th of 2012, and then he applied to retire his license in that same month.
So he's currently listed as inactive, is that right?
That is correct.
And he's not affiliated with a firm, but he doesn't have to be at this point?
He does not have to be at this point. He's applied to retire his license.
But from the period of the time he was released in August of 2011 to May of 2012, was there any grace period at all in there for not being affiliated?
You have 10 days after your broker release to either affiliate with a new firm or to retire your license, or, fill a truck one out to retire your license.
Now, you mentioned earlier this was a violation of Rule 1260.-02.02. Can you look for me, if you would, on 6213 312B subsection 14 and tell me what that provides?
Uh, 6213 312B 14 says, violating any provision of this chapter, any rule duly promulgated and adopted thereunder, or the terms of any lawful order entered by the Commission.
Thank you. I'm going to ask you to look at this document that Ms. Kropp is going to give to you, and ask if you can identify it for me.
This is the citation which was sent by Trek to Mr. Hale.
Anything else in that document?
Yes, there's a initial complaint review by director, and then there's the information from the certified mail where Mr. Jeffrey Hale, it appears, signed for receipt on 5/12 of 2012. It was sent to the firm with which he affiliated at that time, Black Creek Mountain Realty, LLC.
Are there any other documents attached to this?
There's the citation letter that went out to Mr. Hale, which was dated May the 9th of 2012, and attached to the letter was the agreed citation, which sets forth the violation of Rule 1260-2.02, describes his release from Pratt Homes on August 19th of 2011, states that that's in violation of Rule 1260-2.02 and TCA 6213 312B16. It has a citation for $250 as a civil penalty. It then has a copy of the Trek 1 broker release, which was signed by Mr. Pratt, the former principal broker, on 8/17 of 2011. The letter that Trek sent to Mr. Hale, dated August 19th, 2011, advising him that he had been broker released and telling him that a Trek 1 form was enclosed for his convenience to either retire his license or to transfer to another firm. And then there is a copy of his Trek 1 form to transfer to the company on May the 2nd of 2012.
That's some 8 months after he was released, is that right?
That is correct.
Is this entire document put together, is this the complaint file that was sent up to legal for review?
Yes, it is.
Court, please, I'd like to enter this complaint file as my exhibit number.
Exhibit number 1.
The initial citation amount was how much?
$250.
And was there any call from Mr. Hale saying, hey, I can't pay this, can you get all?
No, not to my knowledge, we
Was
did
there
not.
any offer of the reason why it wasn't complied with till 8 months after the fact?
No, not to my knowledge.
Okay. And you heard from Mr. Hale at all?
I have not, no.
I have nothing further.
All right, Mr. Hale, do you have any questions for Ms. Maxwell? All right, members of the commission, questions for Ms. Maxwell?
Ms. Maxwell, do our rules permit, I understand that, and we've had criticism of it in the past too, that you cannot retire your license while you still have outstanding educational requirements. We want to educate the people very well when they're not practicing real estate.
That is correct, that's a statutory.
What if this man says, not only do I want to retire the license, but I want to surrender the license? Can you do that?
You can, well, I mean, you could voluntarily terminate your license, yes.
Thank you.
Else for Ms. Maxwell? No? Thank you, ma'am.
Oh, Julie Crop.
Crop.
Raise your right hand. I solemnly swear or affirm the testimony you give in this cause will be the truth, the whole truth, nothing but the truth, so help you God.
And would you please state your full name?
Lee Crop.
Crop, what's your position with the state of Tennessee?
Assistant General Counsel and Board Attorney to the Tennessee Real Estate Commission.
And as the Attorney for the Commission, you provided a copy of the complaint we just discussed with Ms. Maxwell?
Yes.
And what happened as a result of that complaint?
It was opened in legal, and it was presented to the commission for a probable cause determination as to whether there was a violation of TREC statutes or rules.
And as a result of that, was a consent order drafted and sent?
There was. It was presented. I can double check. It's presented at the August 2012 commission meeting. At that time, the commission authorized a consent order for $500, which was sent to Mr. Hale at his firm address, Black Creek Mountain Realty, where he was affiliated at that time. It was sent on or about August 13th, 2012, and was signed for by I can't read the name. It looks like an Elvenia Mitchell on 8/16/2012.
Have any communication with Mr. Hale or anybody from?
I got a call on 8/16/2012, and in my notes, it was a telephone call from, she called herself Ellie Mitchell. She said that she was Mr. Hale's principal broker. She indicated at that time to me that it was inadvertent. They had meant to pay the citation, and they hadn't done it, and I told her that, I'm sorry, that I apologize, but, someone should have contacted us before then, that the commission wouldn't reconsider it based on that they needed to satisfy the consent order. And she indicated that that would be done, no problem. And that was pretty much the extent of our conversation on August 16th.
What happened after August 16th?
As I typically do for consent orders, or what I do for consent orders when I have not received them back, I send out a final notice, which is just a duplicate copy of the consent order. And one was sent again I believe when I was preparing to send these, I called Miss Mitchell back simply because she had assured me during our phone call that it was going to be taken care of promptly. So I called her, spoke with Miss Mitchell on September 13th of 2012, and she indicated that Mr. Hale had left the firm and was planning on retiring his license. So at that point, I sent the final notice to Mr. Hale at the, I guess what was the home address, what was now appearing as the address in our regulatory board system of 326 Newman Road, Zoddy Daisy, Tennessee, basically providing another copy of the consent order and stating that it indicates that you're attempting to retire your license. This doesn't change anything. This offer is still out there. And that was signed for, it looks like Robin Hale on September 17th.
Have you heard from Mr. Hale at all?
I didn't receive any contact in reply to either one of those. The only contact I had was with Miss Mitchell.
And the violation was what? What was he cited for in the complaint, or in the? What was the part of the law he was cited for?
Tennessee Code Annotated, Section 6213, 312B, subsections 14, which is violating any provision of this chapter, any rule duly promulgated and adopted under this chapter, the terms of any lawful order by the Commission. 6213, 312B, 16, which states, in the case of a licensee failing within a reasonable time to complete administrative measures that may be required by the Commission upon the transfer transfer or termination of any affiliate broker employed by the broker, and Rule 1260-02-.02, subsection 2 of which states, within 10 days after the date of release, the licensee shall complete the required administrative measures for either change of affiliation or retirement. The licensee shall not engage in any activities defined in 6213-102 until a change of affiliation is received and processed by the Commission.
Thank you. Now, you heard earlier from Ms. Maxwell that his license is, quote, inactive. Is that right? You heard that earlier.
Yes, I heard that.
If Mr. Hale were to get the hours he needed and retire, could he then unretire his license and come back and practice full-time without problems with this pending?
It's my understanding that if someone goes into retirement, they can then come back out of retirement.
And even without having addressed the issue?
I believe so.
Hale, questions for Ms. Crop?
Yes, sir.
All right, thank you, sir. Questions from the Commission for Ms. Crop? Yes, sir.
Ms. Crop.
Sure.
You'd referenced 6213-312B, subsection 14.
Yes, sir.
Was that mentioned in the agreed citation that was sent?
I don't believe it was. The reason that that's in there is because the way our civil penalty statute, the way our civil penalty rule is drafted, there is not a specific civil penalty range for violation of Rule 1260-02-.02, but Section 6213-312B-14 allows the Commission to assess a civil penalty for violating any provision or rule. So that is to allow for the Commission to. Does that make sense?
Yeah, so there wasn't a violation of subsection 14. It's just
the violation of 14 was violating the rule.
Right. Thank you.
Yes.
Anything else from Ms. Crop? No? Thank you, ma'am. I'm sorry, Mr. Northern.
As I read the agreed citation, it makes no reference to responding to the complaint, yet in the notice of hearing charges, allegations of fact number 7, cited respondent failed to respond to the allegations.
I will address that.
Okay.
That's just a fact. That's not. That is a fact that I included, but it is just a fact I included. I did not include a violation of the law for failing to respond, if that's your question, because that was not presented to you. It's just a fact.
What I was looking at was, if I read number 5, it says that the respondents offering respondent an opportunity to settle the matter by signing the agreed citation and paying $250 within 14 days of respondent's receipt of agreed citation in order to avoid further legal action. And then number 6 says respondent signed on May 12th. Number 7 says respondent has failed to respond to the allegations. And on the agreed citation, there's no reference to the allegations. I'm just trying to understand why he wasn't told.
If the court pleases, I'll be happy to submit a copy of the consent order that Ms. Kropp drafted that was sent that she was referencing in her testimony. I did not include it generally because I generally don't, but I'll be happy to submit that, and you can look at that if the court pleases.
So at some point he was told that it needed to be.
I'll be happy to present that.
I can.
Ms. Kropp, can you speak to that, or perhaps
I believe
have a copy
so. Do I have a copy of the agreed citation? I think I do.
And the consent order is in the file.
The agreed citation, when it says that they have 14 days to respond to it, that's allowing them a period of time to execute that citation before it is then sent up to me in legal, before it becomes a legal file and then comes before you all. That's what that 14-day period is for. When it came up to me, because the consent order did not include any kind of written violation for Mr. Hale failing to respond to the agreed citation, because it does not direct him to respond to it. And at that point, it's not a complaint, so it doesn't fall under the statute that requires the response within 10 days to the complaint. So he was not written for that as a violation, just purely the failure to take the administrative measures to reaffiliate or retire.
Ms. Kropp, in your consent order, did you cite the fact that he failed to take administrative measures and cite to the law on that particular point?
Just the failure to take administrative measures, not any failure to respond.
And that document was sent to Mr. Hale?
Yes.
And you show proof of receiving that document by signed for by somebody at the address in question?
Right.
And that document contained that information we just spoke of, the notification that he had failed to complete administrative measures?
That's correct. It was only included that we had not, it was included as a fact just to show that when it was presented to you all, we had not received a written response. Sometimes people will send us written responses to agreed citations explaining things, and that would have been included in my facts presented to you all when this was initially presented at the probable cause determination. The fact that he failed to respond to the allegations was merely as part of my presentation to let you all know we sent this agreed citation and we got nothing back in response, so that you all wouldn't say, well, what happened? Did you hear from him? It was just a factual thing. It was nothing that he was cited for.
I understand the fact that there was this lag of time between his dismissal and the Trek 1. But when I look at the allegations of facts, and it says that all he has to do is sign it and send it in, and the next statement says he sent it in.
He didn't sign the agreed citation. He signed for the agreed citation. He signed indicating receipt of the agreed citation.
That's what you're saying.
I'm sorry, I could have answered that much quicker. It was that he signed for the certified mail copy of the agreed citation. The agreed citation was never signed.
I'm sorry.
I'm sorry if that was unclear and I misunderstood your question.
Thank you.
Else for Ms. Kropp? No? Thank you, ma'am.
That concludes the state's proof, Your Honor.
All right. Mr. Hale, why don't you come around over there and sit where the witnesses were?
Raise your right hand for me. I solemnly swear or affirm that the cause will be the truth.
Speaking into the microphone. All right. Mr. Hale, if you would just state your name and address, and then say whatever you wish about this matter to the commission, and then Ms. Ryan may have some questions for you, and as you see from the previous witnesses, the commission may have some questions for you as well. Go ahead, sir.
Jeffrey Allen Hale, 326 Newman Road, Soddy Daisy, Tennessee, 37379. You know, there's the only response that I have to the allegations, as I understood it, you know, now that it's been brought out and many more things have been, you know, presented to me. Yeah, I screwed up. I mean, I take responsibility for allowing the license to just kind of languish without being represented by a broker. That could be, or no, that's not that could be. That is my lack of understanding exactly what my expectations were. I left Pratt Homes, which was the current brokerage house that held my license, without the knowledge of truly understanding whether I signed for it or not. I'm sure I did, and I probably read it and thought I understood it, but you know, I took no course of action for it. I just let it stay there. But if you'll do a little deeper digging, you might see that from the time that I was broker released from Pratt Homes, no real estate was sold. I didn't work in the real estate field. Not that that makes any difference, you know, relinquishing me of my responsibility to have my license represented, but it will show that I was not actively trying to pursue real estate without, you know, going through the proper channel. When I did get affiliated with Black Creek Mountain Realty, it was a new development in Chattanooga. We did not have a broker. I'm not a licensed broker, so I had no broker to transfer my license to. I was given the responsibility by the principals of the company of Black Creek Mountain to recruit and hire a real estate broker, which I did, Ellie Mitchell. When the letter was received and Ellie made correspondence to Ms. Kropp, I understood at that point that whatever fines I had been assessed were going to be taken care of, I guess, or paid for. Again, I'm not going to give you an excuse saying that I shouldn't have done a better job of following up, because it is my responsibility. But, you know, the bottom line is that, you know, I was hired to do a job, and, you know, I did that job to the best of my abilities, and, you know, along with that, I didn't take full responsibility of the things that I needed to do as far as keeping up my education. You know, no mystery there. I let that kind of go. I just didn't do it. I didn't take the attitude that I was bulletproof in this, that nothing could happen. I didn't understand, you know, the severity of where this could lead, and that's the reason I'm sitting here now, is that I do understand it, and it took coming here today and speaking to you fine people on my behalf that I get it. But, you know, again, you know, I just ask for whatever leniency the commission can give me for my lack of knowledge on the issue that we're faced with, or I'm faced with, and hopefully that if I do decide someday that I want to get back into the real estate profession, that I'll have an opportunity. But again, I certainly understand that if the commission decides that that's not the course of action that they want to take, then again, I understand that, you know, I'm the reason for this, and, you know, I'll accept it and move on. Thank you.
Brian, questions?
I have just a couple of questions. Hale, you did get someone did sign for a copy of a consent order sent August of 2012, and then a final one sent in September of 2012. Why didn't you take care of this then?
I received...
You at Soddy Daisy on 326 Newman Road, Soddy Daisy, Tennessee, day delivery 9/17, and the Robin Hales. How come you didn't?
I'm not even certain either if I got it or not. I don't know that I have a copy of that.
Robin Hale, is
Yes.
that an adult?
Yes. Again, I'm not coming up with any excuse.
Why didn't you pay for it? This was on the consent order. It's not even the citation at this point. This is the consent order.
I just explained that, I understand that I had that responsibility, and it's...
And was Ms. Mitchell, or was that the broker?
It is.
And that person signed this the first time around August of 2000.
Apparently not.
You said earlier that was it Black Creek Mountain Realty? Is that the name of the business?
It is.
When they started, they didn't have a principal broker?
They did not.
How long were they operating without a principal broker?
Under Black Creek Mountain Realty, less than 30 days, maybe.
Were any homes sold in that 30-day period, or any pieces of property sold in that time period?
They were not. We did not have land or homes to sell.
And you were broker released at that time, so you really didn't... You didn't have an affiliated license anywhere at that time period because you'd been broker released, right?
Yes, I did mention that.
How is it you felt like you could take this business or start this business, A, without a principal broker up front, and B, without having your license affiliated at any firm as required by law?
At the time that I was brought on board at Black Creek Mountain, I was brought in basically to start making or generating awareness. We, at the time, were still in pre-construction phase, in the land development phases. So I didn't have legal addresses for anything to sell. All we were doing was generating awareness within the community, marketing, advertising, and I was nothing more than just a figurehead for the company.
Did you offer or say these properties were going to be for sale during that time?
I don't know if I did or not. I'm certain that I didn't, because we had, again, talking on behalf of the real estate, I had nothing to sell. It was just vacant land. We hadn't even had infrastructure installed yet, so all we were doing was just trying to, like I said, generate awareness.
Now, I'm going to ask a question. Do you have errors and omissions insurance currently?
I believe I do.
Have you been cited in the past for failure to maintain errors and omissions insurance?
Yes, I have.
So we know that you were cited for that, and we know that for some reason you didn't answer the citation. We know that 2 complaints were sent to you and you didn't bother to answer them. How can we be assured that you're going to pay attention to anything that comes from the state of Tennessee?
I'm here.
That really doesn't answer the question. If we sent certified mail and you don't pay what you've been told to pay, how can we be assured that you're even practicing the way you should be under the laws?
My license is inactive.
Then why don't you just surrender your license?
Surrender it how?
That means you give it up. That means you would not have a license anymore.
Well, I don't want to do that. Just because I'm not practicing real estate now doesn't mean that I don't want to in the future. So
how can we be assured that in the future you're not going to ignore citations, you're not going to or errors and omissions insurance requirements, that you're not going to ignore 2 consent orders sent to you by certified mail? How can we be assured of that in the future?
Because I understand the severity of it now. I apologized for my misunderstanding. I took responsibility for it. I came to Nashville today.
You haven't paid.
Well, that's understood. I think you've already mentioned that.
You didn't try to pay either, did you, sir?
Apparently not.
I have nothing further.
Members of the Commission, questions for Mr. Hale?
I have a question, Mr. Hale. I wrote this down before you got up here, just reading through this. We know what you did about a month before you became affiliated with Black Creek Mountain Realty on or about May the 2nd, 2012.
Mm-hmm.
There's another 7 months in there. What did you do? You said you didn't engage in the real estate, but what did you do?
I went to work for a friend of mine that owned a landscaping company. Yeah, totally unrelated. I did nothing that had any relation to real estate whatsoever. And, you know, if you go back through the records, they will indicate that my name will not show up on any documents that have, you know, transfer of real estate or real property.
Mr. Chair, I have a question for Mr. Hale. Why were you broker released from Pratt Homes?
When I left Pratt Homes, I basically just left the license there, and Mr. Pratt had called and said that since that I had not transferred my license anywhere, they were just going to broker release me to basically release me of any responsibility to that firm.
And you didn't understand what broker release entailed exactly?
Not exactly. What I guess I understood it was that was their way of relinquishing any responsibility of me to them. The 10-day rule or the 10-day law that the Real Estate Commission, I'm sure I knew that. I don't know that, I took no action from that point. From the day that I actually left Pratt Homes and was broker released there was some time involved. I don't know specifically how much.
Are you currently prepared to pay the $250 that was offered on that citation?
I can pay $250.
I didn't understand if you could or couldn't.
Yes, sir, I can.
Chairman, Mr. Hale?
Yes,
what
sir.
are you doing now?
I work for a company that represents utility companies with water, leak detection, water meter products. I go around to all the water utility companies in East Tennessee representing my product.
Looking for leaks?
Yeah, we do both. We unaccounted for water. We sell water meter equipment, reading equipment, digital, analog, items like that.
Mr. Hale, another question I have. I mean, there's a lot of realtors, licensees, real estate licensees in Tennessee that are struggling right now. Is the reason you didn't pay that $250 that when you signed for that agreed citation, it said if you pay this $250, then we'll just close the file, and you're affiliated with Black Rock or Black Creek Mountain Realty. What was the real reason you didn't pay that $250?
I didn't have it. I worked strictly on a commission basis for a company that didn't have a product to sell. I took that position with the understanding that hard work would pay off, and anybody that's aware of what's going on, at least at that community, which I don't know if anybody does or not, it's still kind of foundering. I went weeks, months without pay. So, yeah, $250, $500, $1,000. I mean, that was whether I ate or not. And, I don't want to make that as an excuse because, in order to fulfill my obligations to the company I was hired to, these were things I had to do. It's just like the continuing education. Got to have those in order to keep my license. If I'm going to keep my license and continue to do what I love to do, then I have to do these things. But, sometimes decisions have to be made, and they're hard ones. And, $250 doesn't seem like a lot. And it's not to most people. But at the time when you're working for nothing, $250 is a lot. I'm not proud of it. I'm not proud to sit here and, admit it to the council. But, there is a lot of truth in that.
I have a question.
Go ahead, Ms. Ains. So
Mr. Haynes?
You got some questions?
Yeah, I just got a quick one. When did you first get your license? Two questions, actually. Because I don't see it on
2008, I believe.
2008. And did you sell much real estate when you were with, I guess you were with Pratt Homes the entire time?
No, ma'am, I was not. I was hired originally under the Rarity Communities Group. It's a real estate developments throughout East Tennessee. They were called Rarity Bay, Rarity Mountain, Rarity Club. I worked specifically with the location of Rarity Rivers, which was a bankrupted community. We never even had infrastructure. I worked there for close to a year with, just taking reservations.
But you didn't really sell much real estate.
No, we didn't sell any. The whole company didn't.
Okay, so between 2008 and 2011, you really didn't, when you were active licensed, didn't sell much.
Well, I did when I left and took up my license at Pratt Homes, I did. But from the 2008 till whenever I had my license transferred to Pratt, no, there was no real estate to sell.
And at Pratt Homes was 2 or 3 houses, maybe? Dozen?
In the year, let's see, I'm sorry, I'm not prepared with my dates.
That's all right.
I mean, maybe 2 years that I was with Pratt, I did
you can just
20 homes, maybe.
Okay.
25. So, you can figure over 2 years, 25 homes. That's
okay.
1.5, maybe 2 a month, somewhere in that area. Thank you.
I'm not sure, Mr. Hale, you can answer my questions or not.
Do my best.
Black Mountain Realty, LLC.
Yes, sir.
Was that a new startup company? Or did it have a principal broker before you hired one?
No, Black Creek Mountain did not have a principal broker. We worked under a principal company of Dock Street Communities located out of Myrtle Beach, South Carolina. What they do is they came in and bought a parcel of land behind which used to be Cummings Cove in Chattanooga, 3,000 acres. And they were going to develop it as Black Creek Mountain. Black Creek Mountain Realty didn't exist. All that was understood at the time was undeveloped land to be Black Creek Mountain. So all the interest in the existing community were bought by the investment group that now own the property.
So in essence, if you wanted to transfer your license to Black, did you ever transfer? You couldn't transfer your license because they're not a licensed company anyway.
That's correct. Once Black Creek Mountain Realty was set up and established, Ellie Mitchell was hired as the principal broker. And at that time, I transferred my license to Ellie Mitchell.
Well, Your Honor, I don't think he can answer my question. I need the staff's got to answer this.
Why don't we finish with Mr. Hale, and then we'll recall any of the staff witnesses we need to.
I have a question. I think you halfway indicated you'd like to keep your real estate license, would you not, or would you?
I would like to keep it, but keep it in retirement status.
Okay.
Yes, sir.
Mr. Hale, what do you understand would be required of you to keep your license in retirement status?
As I understand, I need 3 hours of continuing education to take it from inactive to retired.
You know you get 8 hours of education just by attending a track meeting for a couple days? For free?
No, sir. I was never made aware of that. I can't speak on behalf of my broker, but a lot of the things that I had to learn throughout my real estate career, I had to learn myself. Which is to say, when you work for a home builder, which many of you probably know, if the broker is the home builder himself, it's merely just a means to an end. They'd like to be the broker because they can kind of control the circumstances, control their income, control their profits, their losses that way. So, not to say that Mr. Pratt was not a fantastic man and a great person to work for, but as far as guidance in what was expected of me, it was all upon me to make sure that anything that I needed to do, I had to stay on top of it. I'm not trying to say that that's any excuse. I'm not here to, give you any kind of woe is me, speech. It's not. I'm here because I understand the circumstances, and will do my best to help relinquish any responsibility I can.
Donna, can we take a 2.5 minute break?
Yes. Mr. Collins, hang on one second. Mr. Chairman, can I make a suggestion that it's up to the commission to decide if they wish to do this? I think it might perhaps be in everyone's best interest if we took about a 10-minute recess to see whether or not Mr. Hale and Ms. Ryan and Ms. Maxwell could sit down and discuss this matter. I have a feeling that this matter can be resolved without the commission making a decision. If you'd like to do that, Mr. Chairman.
I think it's general consensus around this table that we would like to take a 10-minute break and see if this can get resolved.
Thank you. All right.
10-minute break. Call these proceedings back into session, and Judge Stovall.
All right. Thank you, Mr. Chairman. Ms. Ryan, I see you've had a chance to talk to Mr. Hale.
Yes, Mr. Hale.
You all reached an agreement?
I have. If the commission will approve, Mr. Hale has agreed to pay the $500 civil penalty he was assessed with the consent order last fall, plus the court costs in this matter. He will also attend a 2-day meeting of TREC within 6 months. The court costs and the $500 civil penalty will be paid by the end of April. As with all agreed orders and of all of your licensees, should any term not be complied with, there's an automatic suspension division. But Mr. Hale has assured me that he can get this done by April 30th. We did give him an estimation of the court costs that have accrued thus far, and it is only an estimation, but he is aware of what he might be paying for that.
Mr. Chairman?
Yes.
Move to approve the agreement.
Second. I have one question. Are you sure April 30th? Because it's going to take you a while to get the court costs together.
Not going to take me that long.
Okay.
We have a motion on the floor by Commissioner McMullen and was seconded by Commissioner Grease. Or Alexander. Commissioner Alexander seconded that motion. Is there any discussion on this motion?
I'd just like to hear from Mr. Hale that he's in agreement with what's being stated.
Yes, I do agree.
You think you'll have any trouble raising the court costs by April 30th?
I don't see where I have much of a choice, so yeah, you will have it.
Well, I was thinking about amending it to May the 30th on the court cost only.
Mr. Collins, if it would benefit the conversation, if you would give me about 2 minutes, I could step out in the hall and call my clerk and tell you exactly what the court costs are at this point.
And we do have that already in estimate.
Not counting the court report. I can tell you what my costs are.
I think it's fine.
Would that be
I was just afraid he didn't have enough time to come up with the money.
Okay. All right.
Call for the question, Mr. Chairman.
Question has been called on the motion, which is $500 civil penalty plus the court cost to be paid by the end of April, by April 30th.
Plus the 2-day attendance.
Plus a 2-day attendance within the next 6 months of a TREC meeting. Question has been called. All in favor say aye.
Aye.
Opposed, no. Motion carries unanimously.
Just to be clear, you also understand there is an automatic suspension provision in it. You didn't say that again in your repeat of the motion, but it was included in what I presented.
Is that part of your presentation, or is that the law?
That is what we are required to do now by our... Go ahead, Lo.
It's in all of the consent orders. You all authorized last March, I believe. In all of the consent orders, it includes that. And so an agreed order is essentially a consent order that's been taken a step further. So that's why it would be included in this. We have that in all of our consent orders as well.
Question.
What? We already did.
But
Wait,
she wants that amended.
It wasn't an amendment. I
No.
just wanted to be sure
Yeah.
that you understood what you were voting on was what I presented.
Yes. And that's what Commissioner McMillan's motion was. This, I suppose, Your Honor, completes this formal hearing. And at this time, we are
We're adjourned. on this
adjourned
case,
and,
yes.
yes.
Turned over to you.
Good luck,
Okay.
Mr. Hale.
Good luck, Mr. Hale, and I believe we've had the best judge we ever had.
He's a good judge, isn't he?
He said, hey, Judge, he says that every time we have a formal hearing.
You say that to all the judges.
He says it's all the judges.
He does not.
Thanks very much.
Make a motion with adjourn.
You all should know that the judge is retiring in June.
Oh, no.
But he's coming back part-time next year, so we may get him
Okay.
anyway.
That part of it, that would
good
be
luck.
Commissioner McMullen?
I move that we refer all cases of unlicensed activity to an ALJ for hearing instead of being heard by the full board.
Second.
Have a motion and a second that matters pertaining to licensing.
Like the one we had this morning of unlicensed activity, that those just be heard by an ALJ instead of being heard by the full board.
Since we can't do anything about it anyway.
Is that asking our legal staff, is that something that,
You have the power to decide what cases you want to hear. And if you choose to allow an administrative law judge alone to hear cases of unlicensed activity or any other matter that doesn't necessarily affect the taking away a license, you have the power to do that. Am I right, Judge?
I'm sorry. Say that again.
They have the right and power to determine what cases they will hear and what cases an ALJ alone will hear. And as far as I know, except for suspension or revocation of a license, they could refer on.
No, under the Administrative Procedures Act, and unless your statute says something different, which I'm not aware if it does, but under the Administrative Procedures Act, you can delegate any or all of the contested cases that you wish to the administrative judges to conduct completely, enter findings of fact, conclusions of law, and issue discipline. And it would go out as what's called, well, you may be familiar with it, an initial order, which becomes the final order of this commission unless one party or the other appeals it to you and for your review. Or you can, if you wish, and you could do this by policy, or you could simply direct Ms. Maxwell, I would think would be the appropriate person. I know there are some agencies that, for example, when we issue an initial order, they are automatically reviewed by the commission. So they never become final without going through you for your blessing.
I like that one, too. Could
If
you...
you recall, we did that with the Mountain of E&O.
Right.
We established an administrative law judge to hear those cases, some 150 or so.
Could you make that as a recommendation, Julie, when we hear, when you give us our legal report? Could that be one of your options, or one of our options? You know, possibly you might want to give this to an administrative law judge?
Well, you think it would come down to me, too. Right now, what Mr. McMullen is suggesting is that on this particular issue, that is, as of this morning, if it's unlicensed activity, you don't have to have it heard by you at all. And I suppose there might be some times when I think maybe something should be heard from an ALJ, and if you want to hear that entertained by me, I will be happy to ask if I can have something in the future. But this would be a absolute, if it's unlicensed activity, I would not have to bring it before you, before an ALJ. And any other thing, if right now you have not relinquished control, I shouldn't say control, should I? You have not relinquished the power to hear a case except for errors in admissions insurance. That's the only thing you've given us permission to do before an ALJ alone. But there might be some other times, if you as a commission agree, I can certainly alert you. Those cases I would think might be better heard before an ALJ. but this one is just for this particular, and then we don't have to bring it up every time.
Well, I would just like the option in the legal report to say this may be a good case for ALJ.
But she doesn't make that.
I can't, I think it's her that makes that determination.
We got a second to your motion. Call for the question.
Yeah, we got a second. We've heard the discussion on it. This is something that's very good, and I think that Commissioner McMullen, you have very wisely, again, brought something to our attention that is very good for all of us on this commission. All in favor say aye.
Aye.
Opposed, no.
I'm opposed.
Motion passes 8-1. Let the record show.
Mr. Chair, is it your sense that we will review the ALJ's decision as the final step, or is that, did the motion include that or not?
Go ahead, Judge.
What I would suggest that you do, and just for informational purposes, there is a bill right now going that I believe has passed both houses of the legislature. I know it's passed the Senate. It's about ready to pass the House, where all of the boards and commissions under the Department of Environment and Conservation, water quality, air pollution, all those people, all of those contested cases are now going to be heard by the ALJs, and they are going and they are appealable to the various boards and commissions, because it's basically the boards and commissions under their authority have decided that they simply don't have the time to hear these cases anymore. Now, I will say,
When are you getting out?
I will say that in most instances, at least from my experience, the hearings that are conducted before the environmental boards typically take much longer than the ones that you all have, but they have basically said we're giving all of them to the ALJ. What I would suggest, if you all want to pursue this, is think about it, and then I'd be happy, or me, or my successor would be happy to talk with Ms. Ryan and Ms. Maxwell and Mr. Pugh, and if, provide whatever assistance we can to perhaps figure out a way that they could do that. I would just say this: I'm a little reluctant. I don't think it's the best policy to no disrespect whatsoever to Ms. Ryan, but I don't think it's necessarily the best policy to have Ms. Ryan or someone in her position making the decision as to which way the case is heard. Because if I'm a defense attorney on the other side, I'm sitting there saying, wait a minute, why does my opponent get to decide the forum? Why does she get to decide if you all hear it or we hear it? I think it would be better if you want somebody to be a gatekeeper on that perhaps Ms. Maxwell or Ms. Kropp or somebody who's not litigating the case makes that call. But
I'm sorry, I didn't mean it to come across that way.
No, I don't. Yeah, I don't mean it. I don't think you would do anything inappropriate. I just say that.
And if I'm Ms. Haynes, you should understand that it is not something that's going to bypass you, even the issue of the unlicensed activity, because that's a complaint that's opened and presented. You still have to determine whether there's what we call probable cause, which is essentially what you do on the anonymous factor. And at this point, what you've just voted is that if there's probable cause and if a consent order is not reached and because they've not signed, then instead of having a full hearing before you all, it would be before an ALJ. In answer to your other question, even if it's before an ALJ, there's an initial order drafted, and the ALJ drafts an initial order, an aggrieved party, that is either the state, we could do it, or the other party can still ask that it be reviewed by you all as a commission. That's even before it goes up to the Chancery Court. So there's a multi-layer step for anybody that is aggrieved. It is not a blank, that's it. You have opportunities all along the way to challenge what's been done.
Well, see, what I'm against is putting all the decision-making power on you, because that's not fair to you. And that's why we have a board.
Yes, and I didn't mean it that way. I just meant that there might be, and I think Judge Sobel has the right approach. I was just saying there might be some that might be easier or more appropriate.
Because I think that's what we're appointed for. And again, I've heard Commissioner Alexander also say we make decisions on Julie's report based on the information information we're given, and then when we come to one of these things, the information gets bigger and bigger all the time, as Julie
And
understands.
it happens in all trials, that's exactly
So
right.
I want everybody to have as much opportunity to give their information as possible and not have one or two people to make that decision.
Mr. Chairman.
Mr. Northern.
I would suggest that in light of the comments from Judge Stovall, that we reconsider our previous vote and take it in abeyance and let Judge Stovall or someone discuss it with legal and have that represented to us for consideration at a later meeting.
I'll second that.
What did you make? What was your motion?
That was it.
To rescind the last motion.
To rescind
the last motion.
It was a motion to reconsider the last.
Right.
Motion to reconsider, yeah.
Motion to reconsider last motion, and I have Commissioner Northern's made that motion, and second by Commissioner Haynes. Any discussion? Hearing none. All in favor say aye.
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 No.
Roll call.
No.
Call the roll, Ms. Maxwell.
This is a motion to reconsider the last motion. Is that, and hold the prior motion in abeyance until the legal department, along with some representatives from the ALJ's
Mr. Chairman?
office, can...
Yes.
I move that you have the roll call in reverse.
Do it backwards.
Okay. Stevenson?
Yes. For the motion.
Northern?
For the motion.
McMullen?
No.
Haynes?
Yes.
Flitcroft?
No.
Grease?
No.
DeChara?
No.
Collins?
No.
Alexander?
Yes.
5-4. 5 noes and 4 yeses. Or they get it backwards.
So, no, you got it correct. Commissioner Alexander had already tallied it up in his head. He was ahead of
He
me.
didn't want to make you mad.
So
Okay,
the
so-
prior motion stands that Commissioner McMullen made.
Yes.
Okay, now are we adjourned?
Whatever it was.
Have we got
No,
anything
we got
else?
something else?
Kelly, you had something to talk to us about?
Yeah, Kelly's got something.
Well, get yourself up here and talk to
Come on
us.
up here and talk
That
to
was
us.
a question.
Send us
She
an
said I
email.
do. Do you?
I'll speak up.
Okay.
Kelly is making reservations tomorrow, and as she stated the other day, thank you. As she stated the other day, once it's made, you're automatically going to be hit for one night stay at the hotel, even if you cancel. So she needs to get tentative yes or no from everyone before we leave.
Yes.
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 Yes. Who's not going?
I'm going to give you a tentative yes. That's
But you're going to get charged tomorrow if you say yes.
That's a tentative yes.
You got to make a decision.
Why?
When do you have to have the decision definitely?
March the 24th.
Email us.
But that's when she really originally wanted
Reese,
it,
you
but we
in or
couldn't
out?
even get a contract
I
signed.
gave you a tentative yes.
A tentative yes. Charge his credit card. Don't worry about it.
But wait a minute, I do think that if you know in advance, like a week or so, I did chat with the girl there about crediting back your payment that she's going to take out. But they'll immediately hit your card when Kelly sends them the rooming list. But if you have known in advance you're not going to be able to go, then I'm happy to call the girl up,
Put mine
and
on
she said
theirs.
she'll give your money back.
They'll
In
share
that case,
it.
I'm a yes, as long as I've got the right to later.
Well, now, that's what she said. I don't...
Good looking hat you're wearing there.
He's got his
People
hat
get
on. He's
Wendell
ready
and
to
myself
go.
confused all the time. I'm not sure why.
You thought you'd just wear a hat that's got your name on it?
Well, it sounds like to me that there's going to be 8 of us there for sure, with
And I'm a
exception, and you're a maybe.
I'm a tentative yes.
You're a tentative yes.
I don't know
Is
how
that
many
same?
times I have to say that.
What's the difference between a tentative yes and a maybe?
Well, the cows could come home between now
A
and next
maybe
week.
could go either way. It's likely I'll be a yes. Okay. Tentatively.
Can we adjourn now?
Anybody else?
Move to adjourn.
Business done before this meeting. If not, this commission meeting is adjourned. We'll see you and we'll see.